Yes.
But I have leave to mention a matter with item 21
Yes.
of your lordship's list, my lord. The interim order is till the end of 30th of November, specially assigned to your lordship, my lord. Appeal arises out of an order, my lord, whereby, my lord, my order 9 rule 13 was dismissed against that. Interim order is in, my lord, there we are enjoying it. I've given notice, my lord. In the event if it doesn't reach, my lord, lordship would.
Today we are on 26th.
30th it's Sunday, my lord. That's why my lordship
Yes,
takes
we'll have
up, my lord, only on Wednesday.
Have you given a notice?
Yes, I have given notice.
You're appearing. So there is one number 2. I'm extending for a limited period till end of January, and it will retain its position in the list.
Lordship.
Item 21 ta ekta order report. The matter is taken out of turn for the limited purpose of extension of interim order, comma, upon being mentioned by the appellant. For some next para, since the interim order is due to expire on November 30.
May I,
why? To show that it's is due to expire on November 30, 2025. Sentence start no, the interim order is due to since on November 30, 2025, comma, let the same stand extended till January 31, 2026, or until further order, comma, whichever is earlier, which of the matter will retain its position in the list otherwise.
Grateful.
Thank you.
My lord, may I have your permission to mention a matter, my lord? Similar prayer, my lord, my interim order, item number 27, my lord, my interim order is expiring on 30th November. I'm requesting if this...
Other side.
My lord, I appear for the respondents, my lord. They have not yet filed, my lord, the affidavit in reply which was directed. And my lord,
retains position in the list. Whenever you take up, if they don't file, then we will consider.
Yes. My lord, the difficulty is, my lord, in the section 11 proceedings, they are contending there is no arbitration agreement. This order which lordships have passed is arising out of a section 9 proceeding in the appeal, where lordship prima facie held that there is an...
I put the petition, my lord. It is not a contention that there is no section, there is
cannot-
no arbitration agreement.
Difficulty is we cannot reach these matters. These are short matters, but we don't know when we put it on the list.
I was only praying, I know lordship possibly have to extend the interim order for a very short period. My lord, if it can be, my lord, placed, my lord, for hearing any day convenient to the bench, my lord.
Any day.
We are suffering the
Any day, my lord. We don't have any objection to that.
He can't have it both ways, my lord. Challenging, my lord.
যেটা আগেরটা যে অর্ডার দিলাম সেটাই হবে একদম শেষ পর্যন্ত শুধু লাস্ট লাইনটা হবে যেখানটা বললাম যে দ্য ম্যাটার উইল রিটেন ইটস পজিশন যেটা আগেরটা বললাম তার এই লাস্ট সেন্টেন্সটা কেটে এখানে হবে দ্য ম্যাটার বি প্লেসড under the headings specially fixed matters on December 10, 2025. Specially এটা স্পেশালি ফিক্সডটা ওই যে ডেটে ফিক্স করলাম সেই ডেটে এই অ্যাপ্লিকেশন সেট পরেই দিয়ে দেবে স্পেশালি ফিক্সের আগে এখানে দিয়ে দেবে ওই ডেট থ্যাংক ইউ
Very good. Grateful.
Any other mentioning?
Please give the appearance in the previous matter, Mr. Dotto. Both sides.
This is the mentioning going on. Yes, I have another thing to mention.
Mentioning is we have called.
No, I don't know whether I thought the list has been taken up. That's why
This has been taken up.
Now, just now.
Called 1819, yes.
Yes, just before that it was.
You're mentioning original side matter.
No, appellate side.
We are not taking up appellate. When
No.
we take up the appellate side, we'll take up appellate side. Your mentioning will be taken up then, sir. Yes. Yes, Mr. Yes.
Arbitration Act. Nobody's come.
Maybe earlier also. Some Mukherjee is very precise.
Yes.
And he's on reply.
Precising is yes, up to 12, it can be released.
No, we are not releasing anything.
I say can be released.
Yes, Mr. Mukherjee.
Yes, my lord. My lord, kindly take the act, my lord, the 5th schedule once.
Arbitration.
That's
okay.
That is where we ended, my lord, on the last occasion. Item 2, my lord, of the 5th schedule.
Yes.
Which is identical, my lord, to, my lord, the 7th schedule.
Right.
Now, my lord, here, my lord, there were, my lord, three issues involved. One was, my lord, whether, my lord, my lord, the parties or an affiliate of one of the parties, my lord, whether, my lord, in the context of, my lord, affiliate of one of the parties, my lord, rather than, my lord, a company,
Yes.
or, my lord, an entity, my lord, whether, my lord, the explanation to, my lord, can be, my lord, said, my lord, only to apply to, my lord, a corporate, my lord, party which is a corporate entity.
Precisely.
That is, my lord, one. Second, my lord, was, my lord, what I had argued before your lordships, my lord, currently. And third is, my lord, represents. My lord, these are, my lord, the three, my lord, aspects on which I wish to address your lordship. Now, my lord, the first submission I make, my lord, is, my lord, kindly have a look at the heading, my lord, of these, my lord, lists. My lord, the first, my lord, item 1
Yes.
to, my lord, 14 relates to, my lord, arbitrator's relationship with the parties or counsel.
Yes.
Now, my lord, now, my lord, my first submission to your lordship is, my lord, the meaning of party, my lord, has to be construed on the basis of, my lord, where it appears and, my lord, in what context. Now, my first submission before your lordship is that, my lord, if it's only, my lord, relationship, my lord, with a party that we are concerned with, party would have sufficed, my lord, everywhere. Nothing more needed to be, my lord, added. But, my lord, in, my lord, legal entities, my lord, it's been recognized all along, my lord, can have, my lord, rather than natural persons, my lord, a legal entity, my lord, can have, my lord, a, my lord, situation where, my lord, it's really, my lord, a person in control, my lord, of that entity which is, my lord, having the relationship, or, my lord, an affiliate. And, my lord, that can only be, my lord, possible, my lord, if, my lord, it's a corporate entity. Now, let me give your lordships, my lord, examples. Now, my lord, first, my lord, point I wish to make here, my lord, is kindly have a look at the entries, my lord, which has affiliates across the board. Now, my lord, 2 is one which your lordship has seen. Now, my lord, kindly come to 5. The arbitrator is a manager, director, or part of the management, or has a similar controlling influence in an affiliate of one of the parties, if the affiliate is directly involved in the matters in dispute in the arbitration. My lord, it cannot be, my lord, in respect of a natural person at all here. Now, my lord, kindly come to, my lord, 10. A close family member of the arbitrator has a significant financial interest in one of the parties or an affiliate of one of the parties. My lord, it is in one of the parties, the financial interest. And that can only be, my lord, in, my lord, a corporate entity. Financial interest can be by way of a loan, by way of insurance, my lord, by way of, my lord, shareholding, my lord, in, my lord, preference share capital. It can be anything, my lord.
Yes.
Of the parties or an affiliate of one of the parties. Then, my lord, kindly come to, my lord, 14.
Yes.
The arbitrator regularly advises the appointing party or an affiliate of the appointing party. Because, my lord, at the end of the day, my lord, a, my lord, corporate entity, my lord, has a veil.
Yes.
My lord, it may not, my lord, disclose, my lord, the true owner, or, my lord, my lord, which is why, my lord, we have this concept of an affiliate. Now, my lord, kindly come to, my lord, 15. The arbitrator has given legal advice or provided an expert opinion on the dispute to a party or an affiliate of one of the parties. My lord, similarly here. Now, my lord, this is very important because, my lord, if it's, my lord, to an individual, My lord, it would be, my lord, directly to an individual. My lord, if an advice has been given in respect of the dispute to, my lord, affiliate, my lord, of, my lord, a company, my lord, it's because of, my lord, the relationship, my lord, that there, my lord, could be. It's a conflict of interest, my lord, situation.
And you also have 8. Item 8 is also, that also apparently refers to a juristic entity.
Yes, my lord, I'm sorry, I missed out 8, my lord.
But
Appointing party or an affiliate.
and there also it appears to be a corporate entity.
Correct.
Because otherwise it cannot be
It cannot, my lord.
derives a significant
Financial income therefrom.
It would not be therefrom.
Yes.
Therefrom cannot.
Correct. I'm grateful, my lord. That's now, my lord, kindly have a look at, my lord, 17.
Yes.
The arbitrator holds shares either directly or indirectly on one of the parties or an affiliate of that is privately held.
Same.
Then, my lord, kindly come to, my lord, 20.
20 obviously same.
My lord, same, my lord, or an affiliate. Now, my lord, kindly take, my lord, 30, my lord, 32. The arbitrator holds shares either directly or indirectly, which by reason of number or denomination constitute a material holding in one of the parties or an affiliate of one of the parties that is publicly listed.
Obviously.
And, my lord, 34 also,
Same.
my lord, clear. So, my lord, the intention, my lord, here, my lord, in the context in which it is used, my lord, recognizing that a party can be, my lord, a natural person or a juristic entity, my lord, affiliate has been used, my lord, which is necessary for a juristic entity. Otherwise, that veil, my lord, can actually hide, my lord, a lot of things.
One other argument you may also have, Mr. Mukherjee, that where the provision intends to refer to a human being, I mean, it uses terms like close family relationship and all.
Correct, my lord. That's the second bit, my lord. I was, my lord, coming to that.
And the third would be that it is irrelevant in this case because it's a corporate entity which is a party.
Correct. Corporate entity and an individual. My lord, are both claimants here.
Oh, yes.
Both claimants.
That
Now, my lord, there is no dispute that, my lord, the claimant is in control of claimant 1 or claimant 2 is in the control of claimant 1.
Yes.
Claimant 1 is CNE. My lord, that, my lord, Bhaiya, my lord, Bulaki Das, my lord, was in control of, my lord, claimant 1. There's no dispute on the regard to that. None at all. My lord, well over 50% shareholding. And, my lord, there is no doubt, my lord, with regard to that. So, my lord, there's, my lord, both are there. Now, the question is, my lord, whether, my lord, SSSMIL is an affiliate of either Bhaiya or, my lord, CNE. That is, my lord, the question.
Yes.
My lord, the first thing is, my lord, my respectful submission was that, my lord, as far as individual is concerned, my lord, gets taken out. Because, my lord, individual having an affiliate is not what is envisaged, my lord, in, my lord, these guidelines. It is a corporate entity which, my lord, can have an affiliate. A party which is a corporate entity which can have an affiliate. Second is, my lord, is, my lord, CNE, my lord, an affiliate, my lord, of SSMIL. My lord, here, my lord, it doesn't hold shares. And, my lord, it's not part of a group with a parent. That is, my lord, the explanation. The solar, yes, my lord, the solar system. My lord, we have a parent.
Solar system.
Yes, my lord, that's how, my lord, I would, my lord, look at it.
Best possible.
Yes. Now, my lord, where, my lord, it's only, my lord, a situation which is confined to a natural person. Kindly have a look, my lord, at, my lord, what all has been provided here. My lord, here, my lord, kindly come to 9.
918 you can see right
Correct.
now. Yes.
My lord, arbitrator has a close family relationship with one of the parties. And then it says, in the case of companies with the persons in the management and controlling the company. Then, my lord, 10, a close family member of the arbitrator has a so, my lord, arbitrator, my lord, is there. His, my lord, let us say, my lord, sister, my lord, holds, my lord, a substantial financial interest in one of the, my lord, parties or an affiliate of one of the parties. That can only be, my lord, a corporate entity. My lord, where, my lord, these are, my lord, interlinked, my lord, here. Then, my lord, kindly come to, my lord, your lordship will find, my lord, at 18, a close family member of the arbitrator has a significant financial interest in the outcome of the dispute. So, my lord, outcome of the dispute, my lord, might enable, my lord, this family member to get, my lord, the insurance claim.
Hmm.
My lord, there could be, my lord, such a structure, my lord,
Yes.
which is, my lord, there. Then the arbitrator or a close family member of the arbitrator has a close relationship with a third party who may be liable to recourse on the part of the unsuccessful party in the dispute. So, my lord, these are, my lord, the family relationships, my lord, as far as individuals are concerned. Now, my lord, I want to, my lord, take it a step further. Now, my lord, your lordships, my lord, being shown, my lord, several dictionary meanings, my lord. I want to draw on two of them, my lord, which are, my lord, according to me, my lord, really, my lord, respondent's disclosure. Black's Law Dictionary, 8 I think.
Black you will be referring to.
Yes, my lord. My lord, Black and West.
All right. At Western Institute. Thank you.
My lord, Black's Law Dictionary, 11th edition,
Yes.
I believe, which was, my lord, handed up.
Right.
Now, my lord, kindly have a look at affiliate.
Yes. Yes, sir.
Yes, now, my lord, the page number, my lord, of the, my lord, edition, my lord, is page 72,
Yes.
affiliate.
Yes.
A corporation, kindly see, my lord, right-hand column, a corporation that is related to another corporation by shareholding or other means of control, a subsidiary, parent, or sibling corporation. Now, my lord, this is squarely, my lord, covers, my lord, corporate entities. And second, my lord, is, my lord, talks about, very interestingly, we say sister company. Here, my lord, it's sibling corporation.
Yes. Which is much more.
Yes, yes. Now, my lord, kindly have a look at affiliated group also.
Yes.
A chain of corporation that can elect to file a consolidated return because at least 80% of each corporation is owned by others in the group. My lord, these are, my lord, generally, my lord, deals with, my lord, corporations. Now, my lord, kindly come to West's Legal Thesaurus Dictionary. My lord, it's, my lord, West Publishing Company, my lord, has published it. And, my lord, it's by William P. Statsky. Lordship has that, my lord?
Yes.
Yes. Now, my lord, kindly have a look at affiliate. My lord, it's internal page 33. My lord, it's clear, my lord. A branch, a company controlled by another company, an affiliate, example, affiliate of General Motors, division, subdivision, wing, subsidiary, unit, part, bureau desk, department, chapter, office, local component, arm, member, colleague, associate, auxiliary, assistant, partner.
And it's a noun, used as a noun in
Correct.
the. So we need not go into the verb.
Yes.
All right. Good.
So, my lord, in my respectful submission, my lord, this, my lord, relates to. Now, my lord, last occasion, your lordships also asked me a question that, my lord, I had argued 2024, my lord, has, my lord, an element of individual. Now, my lord, your lordship asked me a question whether it was clarificatory or
Yes.
not.
Yes.
And I had said no. But I must show your lordship, my lord, when I said no, my lord, so that, my lord, I want to be, my lord,
You want to be clarificatory.
no, my lord, I want to be in a worst case scenario.
Right.
Because, my lord, people may pick words from here, there.
Pass the judgment, we don't know. Maybe may pick up on that. You are not
My
clear.
lord, my job, my
Never
lord,
know.
is to, my lord, perform this duty as dispassionately as I can to assist the court. My lord, that's, my lord. So, my lord, when, my lord, I hope my lord, younger days, my lord, I was a bit of a menace. My lord, I used to be much louder and, my lord, but my lord, maybe I'm still loud, but, my lord, it's,
No, you're not.
my lord, with not that much passion, my lord. Now, my lord, I want to show your lordships, my lord, I had handed up, my lord, the 2024. My lord, I had handed up, my lord,
IBA guidelines.
IBA guidelines
IBA
2024.
guidelines factor রয়েছে।
Now, my lord, kindly take, my lord, the forward,
হুম,
my lord, of this.
yes.
Now, my lord, your lordships might have noticed that, my lord, when, my lord, the lifting happened, my lord, if I may use that expression in our act, my lord, the statute, my lord, amendment by way of explanation, and then the schedule. My lord, there is, my lord, no mention of IBA at all.
No,
It is just bodily lifted, and that is noted, my lord, in para 11 of HRD.
like some of our judgments.
My lord, that correct. But my lord, the legislature, my lord, has no duty to acknowledge. But an author, my lord, has a duty, my lord, to my lord
Cannot
acknowledge.
plagiarize.
At
Being a-
least, my lord, yes. At
we
least
are
the
not.
footnote.
Yes, we are not corporate entities.
Yes.
We are human beings.
Now, my lord, kindly have a look at, my lord, I want to show your lordship, my lord, second para of the forward.
Yes.
Consistent with the IBA Arbitration Committee's practice of assessing every 10 years whether its rules and guidelines should be adapted, the guidelines were first revised in 2014 with a view further to a review conducted by a 27 member committee. So, my lord, every 10 years, my lord, built on, my lord, experience, my lord, whatever, my lord, information, my lord, has been gathered, what opinions have been received, my lord, there's a review. Are these guidelines which are in force
Still relevant.
or really working?
Working.
Now, my lord, kindly see whether and how the guideline should be revised requires careful consideration. Now, kindly note this, my lord, data is so important. Determining through empirical analysis whether the practical application of the guidelines has raised the need for clarification or improvement. So it's in their mind, my lord, whether clarification should be done or there should be an improvement. Kindly mark the words, my lord, an improvement. When dealing with a body of principles with wide recognition, deciding on the extent of the amendments is by definition a sensitive exercise, as the objective must be to refine the applicable regime without affecting its rationale. And the rationale, my lord, Supreme Court has laid down, even in HRD. Third person, my lord, whether, my lord, being aware of the circumstances, would, my lord, feel, my lord, that this is not right. Justice might be done, but it may not be seen to be done. Now, my lord.
Refine, but not redefined.
Correct.
Up till now.
Correct. Possible tensions as to how strict the guidelines should be may arise from the wide application of the guidelines, covering commercial and investment arbitration, as well as specialized arbitration schemes. Example, maritime, sports, commodities, legal and non-legal professionals serving as arbitrator, etc. All such criteria must be factored in. Now, I pause here. Lordship will find fifth schedule explanation, my lord, 3. Kindly, my lord, have a look at this. This is also factored in.
Yes. Yes.
Because, my lord, in maritime arbitration, my lord, one has had some experience. My lord, the
Expertise is limited.
yes, my lord, particularly with the terms. My lord, even today when we come to court for an admiralty matter, we are going through, my lord, bill of lading.
I also have experience in a negative sense. That there are specific terms which, unless you know, you have to
Correct. So, my lord,
ask every time.
yes. So, my lord, we carry, my lord, the dictionary. There are several maritime dictionaries.
You carry dictionary?
Yes, I carry it. Because, my lord,
Yes.
and I'll tell your lordships, my lord, FIFO, first in, first out, my lord, we are aware of. Now, my lord, then came, my lord, FIOS.
What is it?
So, my lord, it's Freight Information Operating System of the railways. But railways are there in all ports. So suddenly we find, my lord, there is, my lord, FOIS, my lord, the data is stored there. It's all electronic now. So, my lord, railway receipt issued electronically at the port. Data gets uploaded, my lord, in the FIOS, and that's because I'm doing a matter now, my lord, relating to that. I'll probably forget it, my lord, 3 months later. Now, my lord, kindly see. Under the leadership of the co-chairs of the IBA Arbitration Committee, Sama Haridi and Valeria Galindes and Erika Stein as co-chair, of the IBA Arbitration Guidelines and Rules Subcommittee, the subcommittee, later joined by so-and-so, a new task force was set up for, kindly note,
We have marked revision.
Of the 2014 guidelines. A survey carried out by the subcommittee in 2022 among arbitration practitioners confirmed that the guidelines remain a useful and effective tool, but that a complete overhaul of the guidelines was not warranted. So it's been effective. We are not doing a complete over. Survey did, however.
What should have been and actually? Anyway, the survey did.
Yeah, in fact, my lord, IBA, my lord, it's not necessary that persons drafting, my lord, these, my lord, are very familiar with English. Could be European, my lord.
Yes.
My lord. So, my lord, there, my lord.
Indians on average probably know better English than many European countries.
Yes.
People who know English.
Absolutely. In fact, my lord, many Americans as well.
Yes, sir. Yeah. Exactly.
They were surprised, my lord, that I could speak English. Well, it happened. They're very, my lord, what should I say? Inward looking, my lord, particularly, my lord, the Midwest or, persons who do not come from New York or San Francisco.
And they don't have any idea of geography also in general.
Not at all. But otherwise, some of them have the finest brains, scientific brains. In fact, this person I knew was doing research on the speed at which a butterfly can fly, speed at which a bee can fly. And I was asking him why. He said, we'll find out. But he had a full research grant for this for 5 years. A survey carried out by the subcommittee in 2022 amongst arbitration practitioners confirmed that the guidelines remain a useful and effective tool, but that a complete overhaul was not warranted. The survey did, however, suggest areas where the guidelines might need to be modernized or fine-tuned. So, Millard, kindly see arbitrator disclosure. I am not troubling your lordships with the others. Then, Millard, so, my lord, members of the task force were, my lord, about 4 lines later, after those the members of the task force were thus divided into teams to address these issues, along with a 9th team to examine whether any issues not identified by the 2022 survey should also be covered by a revision of the guidelines. Task force team leaders and members, more than 60 in all, made tremendous efforts to complete their tasks in 1 year. The updated version of the guidelines was submitted for public consultation, including to hundreds of arbitration institutions worldwide. The comments were gathered and analyzed, and particularly when consensus was ascertained among the comments, they were taken into account when adopting the final version. Kindly see, my lord, the consultative procedure, my lord, which is being followed. My lord, at least that's, my lord, on the face of it. We then don't know, my lord, whether any Indian institutions were consulted, whether their views, my lord, were considered. But, my lord, this is what it is. The introduction to the 2024 guidelines describes the overreaching goals and their latest revision. The latest revision, followed by general standards regarding impartiality, independence, and disclosure, and the practical by way of the amendments to the guidelines have sought to emphasize the importance of general standards contained in Part 1, which must also be and cannot be considered subordinate to the application list contained in Part 2 for evaluating so-and-so, etc.
So
then, Millard.
Revision, modernize, updated, amended.
Correct. Millard, this is, Millard, I'm grateful, Millard. That's what I wanted to point out. Yes. And, Millard, kindly also see page 3. My lord, this is, no, this is not page 2 here. Page, yeah, 1 minute, I put it. My lord, page 3, I've read the first para, then kindly come to, my lord, that's page 2, my lord, fourth para I have read.
Yes.
And my lord, page 3,
The page you read is marked as page 3 here because
Yes.
the first page contents page is not
yes, my lord, I have placed, my lord.
Yes, you have placed.
Yes. Now, my lord, so, my lord, in my respectful submission, my lord, nothing, my lord, was really clarified. But, my lord, more importantly, I want to take the 2024 also head on. Now, kindly have a look, my lord, when individuals are introduced, my lord, the explanation regarding affiliate. My lord, kindly take, my lord, this document, page, my lord, 15.
Yes.
The lordship will find that at the bottom.
Yes, the subscript, the footnote.
Yes. Now let us, my lord, examine it.
Yes.
My lord, footnote 1, throughout the application list, the term affiliate encompasses all companies in a group of companies, including the parent company. Now, my lord, next, which shows it's not, my lord, a clarification, it's an addition. That's number 1. Second, my lord, even if this were to be operating, even if it was a clarification, kindly see, and or an individual having a controlling influence on the party in the arbitration and or any person or entity over which a party has a controlling influence. So, my lord, Bhaiya is a party. Does, my lord, he have, my lord, a controlling influence?
SSM.
My lord, this is, my lord, the only way. Because, my lord, as far as the other party is concerned, my lord, no argument on that, no material on that. And it doesn't. My lord, the shareholdings are shown, it doesn't. Here, my lord, and the only shareholding is 26% through a subsidiary, through a controlled company of buyer. So 26%, is it a controlling influence or not? And I have cited, my lord, ArcelorMittal, my lord, on this, my lord. So, my lord, even this, my lord, would not be covered. Now, my lord, I come to a situation, my lord, of, my lord, kindly take the compilation, my lord, which was, my lord, handed up, my lord, by my learned friend. Check associated person. What is it? Associated person in the act, yeah. What is it?
It's not defined in the PNG Act.
Now, my lord, kindly take. এইটা আছে তো বলছি did you give it by way of compilation or did you give it separately? The petroleum and natural gas?
No, so these will lose.
ওই দুটোই দিয়ে দিন তাড়াতাড়ি হবে এইটা পরপর দেখিয়ে খালি ফার্স্টটা হ্যাঁ
Yes.
Now, my lord, my learned friend, my lord, handed up how, my lord, affiliates, my lord, two, my lord, notification. In fact, one, my lord, is a regulation and another is rules, my lord, under, my lord, the, my lord, Competition Act.
Yes.
Now, my lord, kindly see here, my lord, first, according to me, is a wholly irrelevant here, my lord, when, my lord, interpreting, my lord, provisions of another statute, because, my lord, context has to be seen. But, my lord, here, kindly have a look, my lord. Since my learned friend relied on it, my lord, and though I'm opening, my lord, but, my lord, these legal material are before the court already. So, my lord, I would because it's a new bench, I say, my lord, it's, my lord,
Yes.
I am, my lord, really opening though, my lord.
Yes.
I was to be in reply, my lord, apropos this. Now kindly have a look at, my lord, the definition of affiliate here. Affiliate means an associated person in relation to the entity, or the entity in relation to an associated person who participates directly or indirectly or through one or more intermediaries in the management or control or capital of the entity or an associated person, as the case may be. Clearly, my lord, showing, my lord, that these are, my lord, corporate entities. Then, my lord, kindly come to 2, who holds directly or indirectly shares not carrying less than 26% of the voting
But
power.
up to 4, it's corporate.
Yes, my lord.
It's corporate.
Now, my lord, kindly take my lord, clause 4. Affiliate code of conduct referred to in these regulations and hereinafter referred to as the code sets out the manner of the interactions between the entity and its affiliate for the purpose of, my lord, one is transportation and one is marketing. That was being separated.
All right. Yes.
These are, my lord. Similarly, my lord, accounting separation. 5.
But this is probably in a different context.
Absolutely, my lord. It's
Yes. Not even.
now, my lord, all that I'm showing, my lord, is, my lord, even, my lord, with regard to, my lord, under Competition Act, your lordship knows, my lord, if there is a merger or rather what we call a combination, my lord, whether, my lord, there is such a dominant position, which, my lord, by itself is not bad, but, my lord, which will, my lord, result in abuse, my lord, in the market. Because today, my lord, monopolies are not barred. We earlier had, my lord, the Monopolies and Restrictive Trade Practices Act.
Yes.
Now we have a Competition Act. So competition in every form, my lord, is, my lord, encouraged. But, my lord, market dominance should not be abused. So, my lord, we have, my lord, here now these particular rules, my lord, for relating to combination. Now kindly have a look, my lord. Here, my lord, explanation to Rule 2.
Yes.
My lord, Rule 2 says an acquisition of shares of voting rights solely as an investment insofar as the total shares of voting rights held by the acquirer directly does not entitle the acquirer to hold more than 25% of total shares, of which shares are acquired, not leading to acquisition of control of the enterprise whose shares of voting rights are being. In Rule 2, acquisition of shares of an enterprise shall be treated solely as an investment where, as my lord, no, not to have a representation, no right, does not gain a right or ability to access commercially sensitive information, acquirer or its group entities and their affiliates are not engaged in any activity relating to production of similar. My lord, that's market share, my lord. One is, my lord, shareholding and, my lord, control and management. The other is market share.
There is this was probably in reply to your argument that 26% that it has to be
No,
positive,
my lord,
not negative.
yes, my lord, and my lord, Supreme Court, my lord, have cited, my
You have
lord, on,
cited,
my
yes.
lord, on, my lord,
ArcelorMittal has
yes, ArcelorMittal. It has
Yes.
to be positive control, my lord, which has to be shown. There has to be a right, my lord. And, my lord, your lordship's right. Apropos that, they had also cited, my lord, the draft paper, my lord, a paper, my lord, which preceded, my lord, the takeover regulations, where it says that you can have de facto control.
Yes.
In fact, that you have control. So, my lord, on an empirical analysis, it felt that you can have de facto control where shareholding is very widely dispersed. But the fact that you had that control should also be demonstrated. Because you can, today we have e-voting, we have postal ballot. Shareholders don't need to travel to the venue. You just need to click a button now. Like, my lord, earlier delisting of shares, very few people objected because they were getting back the shares at a price which was usually more than the listed price. Now, my lord, people are objecting to delisting. People are objecting to reduction of capital. They say, no, you can't reduce the capital selectively. That is only buy the non-promoter shares. We want to remain. Let us say Philips. Philips is doing well. Why should we give it up? We'll find a buyer. It's not a private company that there are restrictions on transfer. It's a public company. We can go ahead. Now, my lord, I had, my lord, wanted to argue on represents. My lord, I had made a submission to your lordship. My lord, that legal representation is not, my lord, covered here at all. The lordship's response was, no, there are no words of qualification, so why should it not cover,
Yes.
my lord, all forms of representation? Now, my lord, kindly look at, my lord, 11 here.
Yes, 11.
No, I'm aware. My mind is clear. Kindly see, my lord, the arbitrator is a legal representative of an entity that is a party in the arbitration. So, my lord, where, my lord, representation apropos, otherwise, my lord, it would be covered in two.
All right.
There's specific provision, my lord, for legal representation.
His representation is repeated in both.
Yes.
So there would be an overlap.
Correct.
All right.
My lord, if it were, my lord, if legal, my lord, was covered. Now, my lord, currently, my lord, your lordship had said, well, during the arbitration for about a year, there were 11 appearances in one matter or 13 appearances in one.
Yes.
Why can't we call it currently? My lord, I would, my lord, look at currently represent slightly differently. My lord, I'll give an example. My lord, in courts, my lord, quite often, my lord, at one point of time when, my lord, when bank litigation was still, my lord, in the high courts before, my lord, the setting up of the debt recovery tribunal. My lord, juniors briefs, my lord, were with, my lord, very, my lord, poor clients would come and say, application for extension of time to file a written statement. That was before the court then. It was part of chamber business. Fees were 351 rupees. My lord, it was to be moved. Now, my lord, we're moving, let us say, ex parte. The learned judge would say, have you served? So we'd say, we haven't served because we're looking at two fees, one after service. Okay, serve on so and so. Because that law firm or lawyer, my lord, was regularly representing, my lord, the bank. Then, my lord, matters against Indian Oil Corporation. Serve Mary and Company if you've not served them. Later on, it became Mr. Puritosh Sinha. Magma Leasing Hire Purchase. If you haven't served, serve Mr. Pur. That's what's, my lord, meant by currently representing. My lord, that's how I see, my lord, it was, my lord, really.
Ordering on retainership, I mean, almost.
Yes. That's what I said, my lord. It's on retainer or regularly, my lord, appearing. And it's in that context, my lord, I would just request your lordship to once again look at 3 lines, my lord, or 1 paragraph of HRD.
HRD একটা জাজমেন্ট সেট করেছিল ওই কম্পাইলেশনটার মধ্যে আছে ওই বড় স্পাইরাল বাইন্ডিংটা হয়েছিল
2018-12 SEC.
না ওটা খুলে দিন যেমন অর্ডারে ছিল পুরোটা দাও আমি সাজিয়ে রেখেছি যেভাবে ছিল ওইভাবে দাও আমি বার করে নিচ্ছি আলাদা করলাম সাজানো ঠিক আছে দর্শককে দাও Yes, HRD third amendment.
My lord, your lordship's recall, my lord, there were, my lord, requests for removal of 2 learned judges.
Yes.
Justice Dwabia and, my lord, Justice Lahoti. My lord, when considering, my lord, Justice Lahoti's removal, he had given one opinion in an unrelated matter to one of the parties. And, my lord, item 1 was under which, my lord, removal was being sought of the fifth schedule. Now, my lord, item 2, my lord, was also discussed. Now, my lord, kindly come to, my lord, para 22. It starts at 494. Kindly comes to, my lord, 495.
Yes.
Now, my lord, 22. Kindly come to 495.
Yes.
My lord, placitum B, my lord.
Hmm.
Just, my lord, 3 lines, my lord, above that. Though the word regularly
Yes. Yes.
is missing from items 1 and 2, it is clear that the arbitrator, if he is an advisor in the sense of being a person who has a business relationship in item 1, or is a person who currently advises a party or his affiliates in item 2, connotes some degree of regularity in both items. Kindly mark this. Then, my lord, your lordship was pleased to point out to me, here there were 13 appearances.
11.
And 11 appearances and one, my lord, just one opinion. So, my lord, I had, my lord, by way of submission, put a question to myself. Would then one appearance have made a difference? My lord, that was where we were, my lord, when we... Now, my lord, I just want to now here, just read the next 5 lines. The advice given under any of these items cannot possibly be one opinion given by a retired judge on a professional basis at arm's length. Now, my lord, this is what the fact of that case was. Now, the real ratio is, my lord, kindly see, something more is required, which is the element of being connected instead of advisory, my lord, kindly read in a representative capacity with a party. Since justice has only given a professional opinion which has no concern, he is not qualified. My lord, that is the only examination, my lord, your lordships will kindly examine. That's my lord, humble request. My lord, that currently represents. Then, my lord, the others I pointed out, my lord. My lord, really, my lord, it relates to either the dispute itself, which is nobody's case. Then 11, my lord, is also not covered.
We actually also asked you a question whether, Mr. Mukherjee, you would be in that capacity with
No, my lord, nobody would say, call Mr. Mukherjee. Your lordship will call
Nobody
me.
says call Mr. Mukherjee.
No, your lordship will always do it, my lord, when I was for the state.
But then
Then, my lord, whether
I was on the, I threatened dismissal of several matters because you were not there to bring it. Yes.
I'm grateful, my lord. I'm grateful to, my lord, I'm only grateful for being in a position to assist. But, my lord, not grateful, my lord, to always be representing the state.
Yes.
In fact, on a lighter vein, my lord, I was doing an arbitration, my lord, before bench presided over, arbitral, my lord, tribunal presided over by Justice Sirpurkar. And so he asked me, what's your experience? He said, every time I go to court, I'm getting slapped. So he said, that's what advocate generals are meant for. He told me, and so did Justice Matre. They said, get out of this. What made you take it up? And I had my reasons. I've had a good stint, my lord. I'm happy where I am now.
We are also happy that you have for you, actually.
My lord, it's not that, my lord. It's easier, my lord, to deal with, my lord, advocates on record, solicitors, and, my lord, clients who come for a conference than, my lord, representatives of the state.
And an element of rationality is
Yes,
also
has to be
required
there.
at every level.
My lord, several, my lord, officers fully understand. My lord, they put their hands up. Very senior officers, they come, they tell me, yes, we agree with you fully. My lord, I'll give your lordships one example, again digressing. Justice Bhattacharya might remember, my lord, the Rohingya issue, my lord.
Several matters.
I had to impress upon them. I said, what are you going to do?
The ideal situation was for Mr. Bolaira in his the last part of his stint, when the
he was in a position.
Chief Minister came.
Yes,
He was in a position probably to give
yes,
some advice.
the relationship that,
That also.
yes,
Not the last Chief Minister.
yes,
We saw the panels also.
yes,
Because some of the people we know that they are not in any way connected with any
yes, yes.
in that sense. Anyway, so
my lord, I had shown your lordships, my lord, 11. My lord, from the schedule, my lord, to 11. 11 clearly is a legal of an entity that is a party. That is, my lord, not, my lord, the issue here. Then, my lord, 15, my lord, is, my lord, opinion on the dispute. And 20, my lord, again, if your lordships with me on affiliate, my lord, this cannot come in the way at all.
yes.
My lord, I am.
Sorry. There's a distinction between legal representative and counsel, which finds place in, because counsel is used in, say, 21, 20, counsel.
My lord, because, my lord, services.
Yes.
My lord, I again look at the heading which your lordship drew my attention to.
Yes.
That is also part of the context when we are looking at.
But legal representative may include a law officer or
Correct,
something like that.
correct. Can include.
Yes.
My lord, somebody who is not providing services.
Can include. Yes.
Can include.
True.
Because I am saying, my lord, take.
Why does against it?
Why does?
Yes.
Because, my lord, it's really a third person, my lord. Your lordship seen the test. And
Yes, third person.
I think that, my lord, I don't join issue, my lord, with para 74 and 78, my lord, off. My lord, your lordship made me actually sit down and write not on the iPad but on the paper, my lord. So I did after a long time.
Yes, must be.
My lord, it's here, but it gets, my lord, cramped for me, my lord, because 6 screens show up, then it becomes a
Screen size is also a
yes,
factor.
my lord, if I had 2 tablets,
Yes.
my lord, it would have been possible.
Double screen.
Yes, but my lord, I do have, but my lord, my files will all, because
It's difficult to maneuver also. I mean, physically.
no, it's possible, my lord. In international arbitrations, we have 6
You
of them there. In fact, the arbitral tribunal, my lord, has, my lord, 2 each.
We are looking
But,
forward.
my lord, I am now, my lord, High Court.
We don't even have the money to buy a device for that, for the judges.
My lord,
We don't have the money. I mean, the money is not given to us.
My lord, that should happen, my lord.
So good that we are getting our salary still. But we don't have cars even. I mean, cars to ferry between buildings and for other uses. Forget giving individual cars to judges and drivers, as other high courts
My
do.
lord, may I suggest one thing? Kindly don't take me amiss.
You are no longer there. What is the use of your suggestion?
No. My lord, I'll tell you, lordships, my lord, a good walk, my lord, is also a good thing, my lord. Kindly.
No. Mr. Because you don't know what happened. I took walks twice, and the senior partner on my bench rebuked me like anything. Because you see, Mr. Mukherjee, what happens, frankly speaking, the others become insecure. When you do something which you feel is right, there are several others who are not doing it, they all become insecure. That is the difficulty. So, several things I would very much like to do in court, out of court, in between courts, which I cannot do because just to desist from making other people insecure. I'm being very candid. Here.
My lord, it happened to me. My lord, one learned judge sitting in this court, but singly said, "Why are you saying my lord? You should say, sir." I said, "Gladly, I'll do it." I did it. Mr. Pratap Chatterjee was here. Do it in another court and see what happens.
Yes, exactly.
I did it in another court.
Exactly, Mr. Mukherjee. And when we go to districts, obedience is paid unnecessarily. I mean, when you curtail that and the person does not do it then it happens. But here it's a question of money not being given, not for ferrying only.
No, my lord.
For other purposes.
Yes, my lord.
I meant to say that the vehicles are even not provided, which are required. Other high courts provide individual vehicles to, all other high courts almost. So forget about handheld devices and all.
But I do remember tablets had come to the court. I don't know what
Had
happened.
come to, started experimentally in 2 courts. We vied for that, but anyway. So, but that was never introduced because sufficient numbers were not provided. Number of handhelds. As simple as that. Bandwidth, we want more bandwidth, and several other things.
Yes.
And in fact, the issue which caught attention of the bar was behind me, actually, the library club more than association. That issue was originally for that only. Regarding bandwidth, certain appointments were made, 74 or something, for data entry operators, and also that we can get better, more savvy. One stroke of a brush, all the appointments were returned to the government, saying that we don't need it. So that's why I called for a report from the registrar to disclose why these connectivities. That was the underlying refrain. Why the connectivity is not happening. I wanted a report. That report would disclose everything. That was when it started. Pandora's box was opened. So that is happening to us from our side as well as the other side also. That's a difficulty we have to overcome.
My lord, I remember funds were required for translation. My lord, of
Yes.
my lord, which some bit I organized. I know that.
Yes, you organize so many things, but then.
My lord,
Anyway, let us be more
yes, but
optimistic.
I've concluded really, my lord. I'll
Yes.
just yes, my lord. Just my lord. I was on the judgment. Kindly take my lord volume 13, 1599. My lord, I was not, my lord, arguing the case which we did in para 73. My lord, much though Mr. Ghosh would like me to, but I'm not arguing that. My lord, para 74, my lord, कोई आजे ना नहीं चलेगा.
Para 74 of the
Impugned judgment, my lord, page 1600, volume 13.
volume 13.
12 and 13 ऊपर ही लिखे थे मैंने, ओखाने जाके.
Yes, that will be incorrect. ওকে বলো একটু হেল্প করতে, ডাকো একবার, তুমি হেল্প করে দাও.
Lord, paragraph 74, page 1600.
Yes. দেখবেন হাতে চলে আসবে, ওটা অনেক চলে আসবে. Yes.
In addition to the aforesaid breach, the arbitrator also suppressed and failed to disclose before the parties to the arbitration that he had appeared for Triple SMIL Bhaya Group in APD. Chain of events between would definitely give rise to a real likelihood of danger that the arbitrator may have allowed himself to have been compromised and consequently raised justifiable doubt. This court sees the above in no uncertain terms as any reasonable man in the facts of Swens. Now, my lord, whether this disclosure was required to be made or not, my lord, is the issue, my lord, which your lordships, my lord, would be determining. Then kindly come to para 78 at 1601. My lord, I have, my lord, no problems with para 78, my lord. If it's, my lord, made out.
Yes.
This is. Then, my lord, kindly come to, my lord, para 97, page 1613.
Yes.
My lord, this is where I joined issue, my lord.
Yes.
However, this court finds the danger and probability of bias test more acceptable as opposed to the likelihood and possibility of bias test. Even if one were to apply the real danger of bias and probability thereof test, the arbitrator's conduct in the instant case would certainly fall foul of the mandate of so and so, so and so. And that's what I've explained, Miller. Tried to, Miller. And then paragraph 101. Miller and Miller, I say, Miller, that this test, Miller, as I have, Miller, always understood it, has been, Miller, reasonable apprehension of a likelihood of bias. Miller, that has, Miller, Ranjit Thakur onwards, Miller, that is, Miller, been the test. And Miller, HRD has, Miller, pointed it out in the context of our act. Would a third person feel that justice, even if it is done, didn't appear to be done, given the
Must
facts
appear
of
to be
the
done.
case. Yes. Then, Miller, I come to, Miller, paragraph 97, Miller, which I dealt with, then 101, Miller, at page 1614.
Yes.
Miller, HRD, Miller, is cited here, then kindly come to this, I'm sorry,
Where?
Miller, page 1616.
Yes.
Kindly see para 104.
Yes.
Miller, this court is unable to apply the dicta of the Supreme Court in the HRD Corporation case and Sheetal Maruti case to the facts of the instant case, particularly the chain of events and the arbitrator representing the affiliate of Bulakidas Bhaya, the principal party of one side in the arbitration. Then, Miller, 105. That if real, this was that even if it was a casual appearance, there was infraction. So, Miller.
Now, causal connection between him representing such and such. So, if, since the premise is that since he's of some worth in the bar, so a causal connection between him representing SSMIL and the actual award need not be established. So, proceeded on the high ground that even without establishing
that if there is a violation,
he ought to have been more careful.
Yes.
Basically.
Or, Miller, even if it's a mistake.
Yes. Yes.
Miller, even if it's a mistake. Miller, I make lots of mistakes.
No, yes, we don't do.
Daily, at least at home.
Obviously.
Miller, I'm always making mistakes. So, Miller. Then, Miller, comes, Miller, paragraphs, Miller, 106. One also need not enter into the merits. What is it? So, whether represented before the High Court on behalf exclusively and control in management, Miller, this is where, Miller, I join issue saying there's no factual basis for this. I had, Miller, placed, Miller, the earlier reasoning, Miller, of, Miller, the learned single judge. Miller, none of them show actual control. Would reasonably indicate a likelihood and a danger of bias to an uninformed common man and any of the parties. And uninformed is probably not correct. Has to have knowledge of the relevant facts. And then, Miller, grounds 11, 15 and 20. And, Miller, 15 of the 7th schedule.
Yes.
And 15, Miller, is relating to the dispute. Cannot arise at all. And, Miller, 11, Miller, is, Miller, representing the corporate entity. That is also not the case.
No.
20 is, Miller, the council. That's the council. Services rent.
Yes.
Now, Miller, two other cases, Miller, which I wish to show your lordship, which I had, Miller, one of them I had cited, Miller, earlier, which is, Miller, what we have now commonly, Miller, in our High Court at least, my lord. In fact, now I'm finding, my lord, it's pan-India, the Birla matter. So, my lord, that's, my lord, earlier Birla matter, we, my lord, always understood it to mean, my lord, the caveatable.
Caveatable interest.
Yes.
Yes.
My lord, that has gone now. My lord, this is now, my lord, in the foreground. So, my lord, kindly take, my lord, I think a copy is there. If not, I have another copy. My lord, it is, my lord, testamentary
Yes,
and
it is there.
It is there. My lord, just two paragraph.
So, this was challenged before this.
Yes, my lord.
What happened to
My
this?
lord,
We are
leave-
not following.
No, leave has been granted, so appeal will be
But
heard.
that's.
Yes. So, my lord, it'll.
I'm only interested to know on that proposition. I mean, what is the final finding?
Yes, my lord, it's important, my lord,
It's important for other
Yes,
things
yes.
also.
Because, my lord, Birla has been followed in several single judge decisions of our court, my lord, including one, my lord, by your lordship as well.
So we have to.
Yes.
Division bench binds me
Yes,
singly.
yes. So, my lord, kindly take para 103 first, my lord. My lord, at page 227, my lord, the page numbers, it starts at 226. Kindly come to 227, my lord.
Yes.
Bottom of the page, my lord, I'm just showing your lordships, my lord, the issues.
Yes.
Out of the labyrinth of arguments advanced, the following broad issues and sub-issues emanate for adjudication in the, and I must apologize, my lord, for the labyrinth.
For?
The labyrinth, my lord. Maybe, my lord, the matter need not have been argued, my lord, for so many days. That was my view initially. But, my lord, we all fell into the trap which Mr. Kambata said.
No, but we have to speak our minds in subtle language.
No, that's... Powers of probate court under section 247. This question of title, third party injunction. Then, my lord, extent of PDB estate, only shares or controlling interest meaning whether the issue of extent of estate barred by rest, and, my lord, whether they can interfere in company affairs.
The word control is used here.
Yes, controlling interest.
In
Yes. Now, my lord, kindly come to the language used in 5 is controlling influence. But
yes.
the language used in the judgment is control of Bhaya. Therefore, an affiliate. Now, Millard, kindly come to Millard. Paragraph 132. 130, issue number 2, subclause 2. Controlling interest in the present context can only mean the incidental rights, including voting rights, rights of
Please
party.
give us the page number.
My lord, 257. 257.
Yes.
My lord, it's 257.
Good.
2, my lord, 260. My lord, that's what I'll be placing, my lord.
Yes.
Rights of participation in shareholders' meetings and other decision-making processes which PDB would have had by virtue of a shareholding in the respective. The sub-issue pertains to the meaning of controlling interest. The majority joint APLs have accepted the contention of the respondents that PDB held controlling interest in all the companies in MPB group, that is, should be tier 3, my lord, it's gone down as tier 3 and 4 companies by virtue of such shareholding in tier 1 and 2. The respondents have supported the findings of the majority joint APLs by contending that PDB enjoyed, highly note, de facto control dehorse actual shareholding in the company, and such de facto controlled exercise by PDB is part of the estate to be noted. To be noted that in the 1956 Act, control was not defined and was introduced in 2013 Act. Well, that I have shown your lordships, my lord, 220. In Vodafone International, the Honorable Supreme Court held that control is a mixed question of law and fact. Ownership of shares may in certain such situation result in assumption of an interest which has the character of a controlling interest in the management. A controlling interest is an incident of ownership of shares in a company, something which flows out of the holdings of such shares. A controlling interest is therefore not an identifiable or a distinct capital asset independent of the holding of shares. The control of the companies resides in the voting powers of the shareholders, and the share represents an interest of a shareholder, which is made up of various rights contained in the contract embodied in the articles. Further, it was held that the right of a shareholder may assume the character of a controlling interest, where the extent of a shareholding, now kindly mark this, where the extent of a shareholding enables the shareholder to control the management. Shares, and kindly mark the next word, and rights which emanate from them flow together and cannot be dissected. Further, it was reiterated that shares represent, this is actually a quote in Vodafone from another judgment. From another judgment. Conjuries of rights and controlling interest is an incident, now kindly mark this, of holding majority shares. Control of a company vests in the voting powers of its shareholders. Further, it has held that the company is a separate legal persona, and the fact that all its shares are owned by one person or by the parent company has nothing to do with its separate legal existence. In none of the authorities have the assets of the subsidiary have been held to be those of the parent. Well, kindly note this, because Vodafone says even if it's parent subsidiary relationship, that by itself is not enough for control. Well, for the simple reason, which your lordships are aware of, a parent and a holding have to have directors. It's the directors who are in a fiduciary duty to the company. So if 100% shareholder tells the directors to do something which is beneficial to them but not beneficial to the subsidiary, it's the directors who have to take a call to make a correct decision, and that correct decision can only be one, be a decision which benefits the subsidiary and not the holding. Because that is, and is recognized statutorily now, in the Act. And the leading case, on oppression mismanagement, which we keep citing, Scottish Cooperative, 1958, 3 All England, page 66, is exactly that. To the holding and subsidiary, manufacturing cotton and cotton, producing cotton and manufacture of textiles. Now, even though a subsidiary may normally comply with the request of a parent company, kindly see, it is not a puppet of the parent company. The difference is between having power or having a persuasive position. Further, it was held that the legal position is well settled, namely that even though a subsidiary may normally comply with the request of a parent company, it is not just a puppet of the parent. The difference is between having the power and having the persuasive position. A great deal depends on the facts of each case. At this juncture, it would be relevant to take note of the definition of control as defined in. It states that control shall include, kindly mark the expression, right upon the majority of directors, include the right upon the majority of directors, or to control the management of policy decisions exercisable by a person or persons acting individually and in concert, directly or indirectly, including by virtue of their shareholding or management rights or shareholder agreements or voting agreements or in any other manner. In Chintapati, Srinivasa Raju, the Honorable Supreme Court held that even though definition of control in 1997 regulation is an inclusive one, yet the definition shows that the control must mean a right, again, to appoint majority of directors as a shareholder or to control management or policy decision by persons in any manner. Thus, to state that a person exercises control, the true meaning and color to be given to the words in the definition of control in 227 should mean that there should be a right, and this would be the correct way of interpreting the meaning of the control as defined in 227. The argument of the respondents is that it is an inclusive definition, as the definition of control states that control shall include the right. Then in Reserve Bank, the question which fell for consideration is a price check price, let's state a price state. While deciding the question, the Honorable Supreme Court decided the significance of the word includes and what an inclusive definition implies. Both parties to the litigation placed reliance on the decision of Dilworth, wherein it was held that the word include is very generally used in interpretation clauses in order to enlarge the meaning of the word or phrases occurring in both. And when it is so used, these words or phrases must be construed as comprehending not only such things as they signify according to their natural import, but also those things which the interpretation clause declares that they shall include. It was further held that the word include is susceptible of another construction which may become imperative if the context of the act is sufficient to show that it was not merely employed for the purpose of adding to the natural significance of the words or expressions defined. It may be equivalent to mean and include, and in that case it may afford an exhaustive explanation of the meaning which for the purpose of the act must invariably be attached to these words. Therefore, the bone of contention is not as to whether the definition of the word control is an inclusive definition or an exhaustive definition, but what is most important to note in the definition of the word explanation is that there must be a right to appoint majority of directors or a right to control the management or policy decisions exercisable by a person or persons acting individually or in concert directly or indirectly, including by virtue of their shareholding or management rights or shareholders' rights or voting so and so. Therefore, the word right as contained is of utmost, and the definition of the word control cannot be read to mean something divorce the existing. And the finding is that Bhaiya is in control of SSMI. So, my lord, that it should be, my lord, not just merely de facto, it has to be a right to control. Now, my lord, kindly take Vodafone, my lord, which your lordships have referred to extensively here. It was a tax, my lord, case, but my lord, I will.
We are at the end.
19, hold it.
On the compilation that
My lord, I don't think Vodafone is there.
we did, sir.
My lord, I had just referred to it. Wait, give them a copy. Give them a copy. It's heavy. He said it's heavy.
No, acha.
My lord, Hutch was acquired by Vodafone.
Yes.
My lord, the ultimate holding company was outside India. The transfer happened there. Downstream, my lord, no transfers. Question was, my lord, whether, my lord, there was, my lord, a transfer of a capital asset in India which was liable to tax. This was, my lord, in short, my lord, the issue. Now, my lord.
Liable tax in India, obviously.
Correct.
Yes.
They said, well, the control of this company has changed. So there is a transfer of ownership. It might have been in a situs which was well outside India, which had this, my lord, domino effect or cascading effect, so they said, no, transaction in reality was to have change in control of the Indian operations. So you have to pay tax. Now, my lord, here, kindly take in that context. My lord, paragraph 100 at page 676. My lord, I'll tell your lordships the paras I will read. 100 to 106. Yes. And my lord, para 159. My lord, which is 676 to 679. And my lord, at my lord, page 687.
Yes.
Be that as it may, did HTIL, that's Hutchinson, my lord, possess a legal right to appoint directors onto the board of HEL, and as such had some property right in HEL. This is all the Hutchinson structure. If not, the question of such a right getting extinguished will not arise. A legal right is an enforceable right, enforceable by a legal process. The question is what is the nature of the control that a parent company has over its subsidiary. It is not suggested that the parent company never has control over the subsidiary. For example, in a proper case of lifting of corporate veil, it would be proper to say that the parent company and the subsidiary form one entity. Kindly mark the words, man. In a proper case of lifting of corporate veil. Corporate veil can't always be lifted. Even if parent and subsidiary, it will not be lifted unless there is some statute which requires the corporate veil to be lifted, or it's a subterfuge. Now, Millard, kindly Millard, see Millard, but barring such cases, the legal position of any company incorporated abroad, that its powers, function and responsibilities are governed by the law of its incorporation. No multinational company can operate in a foreign jurisdiction save by operating independently as a good local citizen. Now, Millard, a company is a separate legal persona, and the fact that all its shares, kindly mark this, are owned by one person or by the parent company has nothing to do with its separate legal entity. So, Millard, today we even have under the Act possibility of a one-man company. Millard, it's the Salomon and Salomon dicta, Millard, which is now flowing down. Now, if the owned company is wound up, the liquidator and not its parent company would get hold of the assets of the subsidiary. In none of the authorities have the assets of the subsidiary been held to be those of the parent unless it is acting as an agent. Thus, even though a subsidiary may normally comply with the request of a parent, it's not just a puppet of the parent company, which is, Millard, where your lordships have paraphrased Vodafone, Millard, your lordship. The difference is between having power or having a persuasive position, though it may be advantageous for parent and subsidiary companies to work as a group. Each subsidiary will look to see whether there are separate commercial interests which should be guarded. Then, Millard, when there is a parent company with subsidiaries, is it or is it not the law that the parent company has the power over the subsidiary? It depends on the facts of each case. Now, Millard, next is important. For instance, take the case of a one-man company where only one man is a shareholder perhaps holding 99% of shares, his wife holding 1%. In these circumstances, his control over the company may be so complete that it is his alter ego. Now, my lord, I rely on this as well. Because, my lord, alter ego, my lord, we keep saying, my lord, fairly loosely. My lord, to be an alter ego, my lord, something much more. My lord, absolute control. Now, my lord, but in case of multinationals, important, their subsidiaries have a great deal of autonomy in the country concerned, except where subsidiaries are created or used as a share. Of course, in many cases, the courts do lift up the corner of the veil, but that does not mean that they alter the legal position between the companies. The directors of the subsidiary under the articles are the managers of the companies. If new directors are appointed even at the request of the parent, and even if such directors were removable by the parent, such directors of subsidiary, kindly note this, will owe their duty to their companies. They are not to be dictated by the parent company if it is not in the interest of those companies. The fact that the parent company exercises shareholders' influence on its subsidiaries cannot obliterate the decision-making power or authority of its subsidiaries' directors. They cannot be reduced to puppets. The decisive criteria is whether the parent company's management has such steering interference with the subsidiary's core activities that the subsidiary can no longer be regarded to perform those activities on the authority of its own executive. All this, my lord, has to be, my lord, established. Now, my lord, here, my lord, SSSMIL, my lord, is a listed company. When it was Chem Crown, it was a private company. Shareholdings, my lord, got diluted. Directorship became more widespread. Now, my lord, before dealing with the submissions advanced on behalf of the revenue, we need to, my lord, I don't need to trouble you a lot, kindly come to 105. As regards the right of HTIL to direct a downstream subsidiary as to the manner in which it should vote is concerned, the legal position is well settled, namely that even though a subsidiary may normally comply with the request of a parent company, it is not just a puppet. Differences between having the power and having a persuasive position. A great deal depends on the facts of each case. Further, as stated, a company is a separate fact that all shares are held by one or a company has nothing to do with the, therefore, though it may be advantageous for a parent to work, each subsidiary has to protect its own separate commercial interests. Then, my lord, kindly come to 159.
Yes.
My lord, kindly see Placidum G. A controlling interest is therefore not an identifiable or distinct capital asset, independent of holding of shares. Control of a company resides in the voting power of its shareholders, and shares represent an interest of a shareholder, which is made up of various rights contained in the contract embedded in the articles of association. And my lord, 160 also your lordship may add, my lord, after considering the cases, last sentence, thus control and management is a facet of the holding of shares. Which one?
CW.
Yes. Now, my lord, I've concluded. Only one thing I just want to, my lord, put on caveat, my learned friends, because they have, my lord, 77 volumes, my lord, were filed. My lord, in matter, when it was being heard, and my lord, 36. My lord, where, my lord, the point has been taken with regard to disqualification, there is no specific reference to, my lord, these documents.
In the section 34.
Yes, my lord, 77 volumes of the arbitral records. My lord, where this point has been taken, my lord, these have not been referred to at all. But my lord, when arguments were started, my lord, these were being referred to. I just want to, my lord, before I don't know how, my lord, it will be placed now. I'll deal with that. But my lord, I just want to put a caveat, my lord, that, my lord, what, my lord, was not relied upon in making out a case, my lord, cannot be permitted to be relied on now without, my lord, it ever being stated anywhere that this is the reason for, my lord, a disqualification under any of the schedules. Not that my argument will change much even if they rely on it, but my lord, this is, my lord, the situation. There's one judgment which of our High Court. My lord, I'm not going into Supreme Court here. My lord, 72, is it here? No, the page.
Yeah. 72 CW and 117.
And
At the end, it's highlighted. It's your copy only.
oh. My lord, 72 Calcutta Weekly Notes. My lord, it's of course, my lord, a judgment of a learned single judge, my lord, but
No
with
difficulty.
my lord,
Looking at the learned single judge.
my lord, felicity of expression, my lord, is
More
also
binding
there.
than many division benches.
My lord, what was argued was, my lord, certain facts had not been disclosed to court. Answer to that was, why you say it? It's all a part of the adixtures of the petition. So there cannot be a case of suppression. Now, my lord, when, my lord, dealing with that. Para 15.
Yes.
I am further of the opinion that the application is not bona fide and there has been suppression of material facts from the court in the petition presented. It is nowhere stated in the petition that petitioners 2 to 5 have submitted their nominations for the further or fresh election to be held and have participated in the said election. It has been submitted on behalf of the learned counsel appearing on behalf of the petitioner that this fact will appear from the documents which have been annexed to the petition, and therefore it cannot be said that there has been any suppression. In my view, in the facts of the case, it is not enough, and the petitioner should have clearly stated that these facts in the body of the petition itself and should have offered their explanation with regard to the same if they had any to offer. It does not appear to me that the petitioners 2 to 5 have any explanation to offer with regard to their conduct in having wholeheartedly participated at the further election. And to my mind, it appears that they moved this application at the very last stage when they might have realized that there was little possibility of their succeeding at the election malafide to stop the said election, to continue their position and control in the committee. In view of the conduct, they are not entitled to it.
But here there was a material suppression of a fact of which they owed an explanation.
Yes. Now, my lord, I extrapolated one step.
Yes.
So, my lord, it went against them that you suppress this.
Yes.
Court looked
Suppression
at
is
it.
somewhat different from
Yes, but my lord,
positive argument.
yes. Now, my lord, here now, my lord, these were not taken, my lord, as a ground. Any of these documents.
No, in fact, Mr. Mukherjee, we have also held in judgments that, I mean, if there are within the four corners of the pleadings, there are so many things. Unless specifically argued and dealt with by the court,
Yeah.
probably it should be construed that you either gave it up or not to that level.
Correct.
At least did not rely on that
Correct.
at the time of argument.
And, my lord, your lordship seen, my lord, the learned judges, my lord, judgment.
Yes.
None of these find any reference there.
And if suppose that was argued at the time of hearing,
Yes.
and the judge did not record it,
Yes,
then you
that's
have to plead that in your
correct. Correct.
in sections.
Correct.
Sir.
That is not.
That should be what it is.
Yes,
Sir.
that's not.
That is our perception
Yes.
also.
Yeah.
So
My lord,
this is
those
all.
are my.
Great. We'll come back in 10 minutes and hear
My lord,
the.
they I thought wanted, my lord.
Oh, yes, obviously.
On the next 3rd of December.
Great. Heard learned senior counsel appearing for the appellant, full stop, on the prayer of learned counsel for the respondent, comma. The matter is adjourned for further hearing till December 3, 2025. 3rd December. Okay?
Well, this is my application, Lord. Application, Lord, I am paying, Lord, extension be granted, Lord, to vacate the premises. Lord, what happened, Lord? Degree was passed in against me, Lord. Your Lordships confirm the decree in appeal. Lord, I am already issued a letter to the dealer as well as, Lord, the landlord to give 6 months time to vacate because, Lord, it is a petrol pump, Lord.
You give an undertaking.
I have issued a letter to the landlord. Lord,
No, no.
this
You
letter
are suffering an eviction decree.
Lordship.
Well, an eviction decree passed, my lord, way back in 2014.
An appeal.
Mean profits, my lord, calculated up to 2014. Money deposited with the registrar. I have not got the money. It is subject to further orders of court. My lord, the matter was pending, my lord, for so many years because of the controversy regarding, my lord, the position of a Tika tenant, my lord, in view of the judgment of the Supreme Court. My lord, thereafter, my lord, the matter was resolved. The matter came up before your lordship's. Point taken was that, my lord, we should go back, my lord, we had to go back before the Tika controller. Your lordship's, my lord, ultimately ruled against that proposition and, my lord, held that no, the decree has to be passed. So the appellate court confirmed the decree in September. My lord, we are now in November. 3 months, my lord, they have, my lord, not offered us anything. Now, my lord, your lordship had stayed the operation of the, my lord, of your lordship's decree till October. My lord, since there, my lord, a petrol pump and, my lord, they would, my lord, they said that they would like to prefer an appeal. Now, my lord, they have now come and filed an application saying that they have no desire to prefer an appeal. They want to hand over the property. But, my lord, they now want 6 months' time. My lord, I was respectfully submitting that, my lord, they have already got 3 months. My lord, after your lordship's judgment and order.
Where have you stated that you would not prefer any appeal or that you want to vacate?
I have written a letter to page.
So let us see the averment in the on oath. We want to see that. Because if you after this you do that, because that will be pulling one on
your
them.
lordship record it, not I will not.
No, your statement only, your client statement has to be there. That you want to vacate. Para 4.
Para 4.
And the letter is at page?
Letter is at page 27.
Data may be not considered. It is not itself.
I have also issued a letter to the dealer, my lord, to vacate. Lord, they have filed an appeal, application, lord, in the city civil court and got an injunction. Lord, there I am contesting. Today is the date in the city civil court.
You are the?
I am the Hindustan Petroleum.
Yes, you are, yes.
I am the Hindustan Petroleum.
So the property, the subject, suit property is in physical possession of the dealer.
Of the dealer.
So then how can we vacate even?
Because I have the suit property is, Lord, they are supplying the petrol pump. Petrol.
It was filed against you. Dealer was not a party.
No, dealer was not.
So you are suffering a decree. Even if we give you this liberty, I mean, how can you vacate, deliver vacant possession of the premises? Dealer is enjoying an injunction against you.
I am contesting in the city civil court. No, I am trying.
City civil court dealer has filed a suit and obtained an injunction against my lord Hindustan Petroleum.
From evicting him, the dealer. So then even if we,
landlord is a confirmed, landlord is a performer.
No, we understand fully, but you cannot honor your undertaking then, because after 6 months that suit will be continuing. So if you are injuncted in that suit, you cannot give vacate possession.
Trying to vacate the injunction.
No. You keep on trying, but they will execute the decree and let the dealer come up in order 21/9701. We will not say that.
I have not stated, but I am straight away.
No, you are right. You are absolutely right. But since you have referred in your letter also, you have referred to that suit probably.
Yes, I have referred to the suit.
You have referred to the suit. Yes. So there is already
a 32. Order is also annexed.
I have also annexed the order.
Injunction order.
Yes.
So how can you even hand over vacate possession to them? You will be in contempt of that order.
Yes, Lord, that's why, Lord, I am contesting there. Lord, I am trying to, Lord.
No, we are refusing. The present application has been filed seeking further 6 months. S por apostrophe. to vacate the premises. Full stop. The petitioner, comma, being the judgment debtor, comma, suffered a decree of eviction. We affirmed the decree,
Yes.
which was affirmed by the which was affirmed in appeal by this court. Full stop. While so affirming, comma, on the prayer of the judgment debtor stroke petitioner, comma, a limited stay was granted till October 31, 2025. Push up. Next para. Learned counsel for the petitioner now submits that the petitioner does not intend to prefer any appeal against the said judgment of the appellate court and wants to vacate the premises within 6 months. Push up. Next para. Learned senior counsel appearing for the decree holder stroke opposite party points out that already about 3 months time was granted to the judgment debtor to vacate the premises. Full stop. However, comma, at this juncture, comma, the judgment debtor is now seeking to prolong the time further. Full stop. Next para. Upon a perusal of the averments made in the application, comma, we find that the petitioner submits that they would deliver vacant possession of the site to the authorized owner, that is the that is the decree holder. Full stop. Next para. However, comma, it is evident from the letter written on behalf of the judgment debtor to the decree holder that at present, comma, a title suit is pending at the behest of the dealer under the judgment debtor, comma, which is in actual physical possession of the suit property and has obtained injunction in its independent suit against the judgment debtor. Full stop. As such, comma, even if we were to grant further time of 6 months to the judgment debtor to vacate the premises, comma, the judgment debtor might not be in a position to vacate such vacant and unencumbered possession to the decree holder in view of the subsistence of the injunction order as well as the pendency of the suit at the behest of the dealer itself. Full stop. Hence, comma, a grant of further time to the judgment debtor would be a futile exercise and would unnecessarily prolong the agony of the decree holder. Full stop. In view of the above, comma, GA 12 of 2025 is dismissed on contest without, comma, however, any orders to cost. Liberty is granted to the decree holder to immediately proceed with the connected execution case. Full stop. It is expected that the executing court shall decide the said execution case as expeditiously as the business of the said court permits. In terms of the timelines granted by the Honorable Supreme Court in various judgments.
Application.
Yes. Yes, sir.
My lord, I appear on behalf of the petitioner, my lord. This is my application for registration.
Registration
Yes, my lord. 3 applications have been
within time.
my lord, 3 yes within time.
Not serve copy at least.
Well, I shall serve copy upon there.
The main matter be taken up.
My lord,
No, we may reject the registration also. Filed within time.
yes,
Yes.
within time, my lord, your lordship, kindly, my lord, I shall serve other parties also. They are appearing and other parties are.
So Mr. Basu and Mr. Banerjee are appearing for different parties.
Yeah, different parties are the same.
Same
Like
both?
for the trust, he is for the.
So there are other parties also. I shall serve upon all the, my lord, parties.
When?
Yes, I have not served, my lord. You also kindly permit me to take up, my lord, next, my lord, the 3rd of December. I shall serve all the parties. And
No, the registration, when the order was passed, they were present. Oh, they were.
Your lordship's order.
No, then Mr. Basu, the other respondents. Oh, you only KMD is here for KMD.
All these are the parties.
Well, there are other parties, well, in the appeal and other writ applications. Well, there
No,
are
but then
Nobody else appeared on that
nobody
day.
else appear.
KMDA was there, we were there.
9(4) order 9 rule 4 principle will apply vis-a-vis them. We are allowing them and taking up the whatever appeal.
yes, my lord, your
There,
lordship,
there are PILs and appeal.
there are 3, my lord, 2 writ application and 1 appeal, my lord. Your lordship kindly fix a date, my lord, on 3rd of December. I shall, my lord,
No, but Mr.
Place the-
Basu and Mr. Banerjee, others might have been watching the other respondents. They should be served at least.
Yes, my lord, your lordship kindly fix the
Still
date.
adjourning it,
I
let
shall-
it be served on them and fixed a date. On
Yes.
that date, your lordship will allow this application and main matter will be taken.
Yes, my
That
lord.
is difficult for
That is also my prayer, my lord. Your lordship kindly take up on third.
And hear out the main matter.
And main matter.
Because
That is
ultimately,
not your prayer.
that is exactly what this.
Now, how many other defendants, respondents are
My
there?
lord, in each application, there are 21, my lord, my lord, respondents. My lord, in
No,
another.
we are allowing the restoration application and
Yes, your lordship.
putting the main matter in the list next.
Yes, yes.
Don't allow this. I'll keep it. We on the recorded results there, we will concede on that date.
That's your instruction.
Instruction is my lord, একসঙ্গে হবে এই সিস্টেমই কোডে
No.
No, your lordship kindly allow this. my
Now
lord.
it's not possible. No longer possible because there's so many.
my lord is fixing a date.
Because we want the appeal to be heard out. I'll tell you, Lordship, very frankly.
Obviously, but
Because we don't, because otherwise the pleas this will continue till next election. The whole thing will just continue. That is why we will, as soon as possible, Lordship to hear out.
it's very difficult, Mr. Banerjee, because the other matters are also.
But
That's
this will
why-
not take too much time for
That's
your
why
Lordship.
you are saying,
Everybody says that.
no. I'm not saying that. What I'm submitting, my lord, if it is allowed today, then matter may not be taken up. If it is not allowed, pressure will be there.
The petitioner shall serve copies of GA5 of 2025 on the non-appearing respondents and file an affidavit of service to that effect on the returnable date. The matter shall next be listed on December 10, 2025
Well,
under the
there
same heading.
There are other two applications, my lord, filed my lord, in connection with the REIT application. So,
Unless we allow this,
yes, my lord, that should appear, my lord, on that day.
Listen,
Well, that is not
give
yet-
the numbers. Give the
Yes,
numbers.
that is not appearing in the list today. I am
No, give
giving
the numbers.
Yes, I am giving the number.
আচ্ছা যেটা বললাম কমা দিয়ে একটা along with the other connected application.
Yes, yes. I am giving
Give the numbers, other numbers.
Yes,
উপরে
I
একটু দেখো এগুলো other গুলো অন্যগুলো দিয়ে দিও।
Your Lordship is direct service upon everybody, not just non-appearing.
Non-appearing respondents, not আচ্ছা
No.
non-appearing কথাটা
Let us see what has been written there.
on the respondents.
What story?
On the respondents. Yes. বেতন করা হয়। দুটো extension hearing হয়ে গেছিল। Mr. Mukherjee, this time both of you may argue in a nutshell. I'll do the rest. I'll. So just argue in a nutshell because you have extensive.
This bench has changed.
That is why we have kept it as 2 dimensions, especially as in after cancelling the.
You can not
You can
the
just sit in a nutshell and we'll take the
It can't be before the same bench. Same bench not possible.
same bench with Justice Kumar. Justice Kumar is sitting in a different bench.
Very well.
So it would have to, we'd have to sit together for days, going by the previous arguments.
No, because now I will be starting my rejoinder really. But then let me give a
Put it in a nutshell, we'll have a new hearing, but
so
just put it in a
Lordship,
nutshell. Because the records are there and we'll have a sitting among ourselves and
May I pray for a liberty, my lord? I've been led by Mr. Kaur, my lord. We have concluded our argument before the after Mr. Mitra.
Mr. Mitra will re-argue.
Complete
Normally
kind of
re-argue, but you
give us
reacted
another
the same
opportunity so that
points
we
in a
can.
nutshell. Mr.
then
Mitra also
Mr.
do that.
Majumdar is also there because he's in the
Now,
other
this time you are in a better position because you know their arguments. So you'll be in your main arguments. You can touch the rejoinder points also, and they'll say whatever they have to say. If they have anything else,
because my rejoinder itself would have taken some time. So I can't be too much of a because they've argued for several
as
days.
as short as possible. Because you see, so many appeals are regularly assigned. Matters are being assigned, so it's very difficult for us to. So just as short as possible.
There are charges. Well, the case essentially involves the professional misconduct of two chartered accountants, Aditya Lodha and Harshvardhan Lodha.
Mr. Mitra, give us 2 minutes. We'll just.
না সামারি করে চার্জগুলো 4 ঘন্টা 3 করে বলা আছে চার্জগুলো ভাবে সামারাইজ করা আছে।
Yes, Mr.
So these two professionals, chartered accountants, there are under the Institute Chartered Accountants Act, as prevalent at that time, there are two bodies. There are 3 stages this disciplinary proceeding is. Firstly, it goes to the council. A complaint by an individual, by a chartered accountant. The complaint is entertained by the council. There are 2 bodies, council and disciplinary committee. Council entertains the complaint if it so desires, and then gives an opportunity to the accused members to give a written statement. So it is like that the complaint is treated like somewhat like a petition and our objection, to which the complainant gives his rejoinder, and maybe a surrejoinder in some cases. Thereafter, the council decides whether or not to refer it to the disciplinary committee. Once it is referred to the disciplinary committee, it is like a criminal case. That's our argument. It becomes institute versus me, versus the chartered accountants, the accused chartered accountants. And before the disciplinary committee, there is extensive argument, evidence also placed, examination, cross-examination. Disciplinary committee forms an opinion on all the charges, gives their views, the disciplinary committee, and then the matter goes to the council. Then comes the council's power. On certain kind of offenses, the council has the power to take a decision. And the rest of the offenses, the council has to refer to the High Court for High Court's decision if they find a member guilty. That is also in the statute. Now, in this case, the essential charges, basically the essential charge so far as charges 1 and 4 are concerned. Charge 1 and 4, why am I saying? Because these are the 2 charges on which the council took a decision, which is within the council's powers under section 22 and 22. Council's powers, so that the council took a decision. Now, upon the council taking the decision, I am the aggrieved chartered accountant who was suspended for 6 months, come up in appeal. Both these charges relate to number of partners this firm has. Number of partners in the sense that whether there are 3 partners or 8 partners or 14 partners. Now, why is this issue coming up? Because somebody has complained that I am showing more partners than I have in order to get more audits. Because empaneling authorities, number of partners are required to be stated. And certain empanelment, you need more number of partners, like, for example, Comptroller, Auditor General, RBI. Then also for Companies Act purposes, because number of audits depend on number of partners. There is a partnership deed of the year 2001. Yes. The partnership year 2001, which says there are 14 partners, and all are not full profit sharing. Some have a fixed profit. This is also contemplated under the Chartered Accountants regime, Chartered Accountants Council regime, because as and when a firm is reconstituted, a form has to be filed with the institute, which also requires us to state whether all the partners are profit sharing or not. So the institute, when in 2001 the partnership firm was reconstituted, we submitted the form giving the names of all the partners, 14 or so partners, and we also, against that printed line, whether all the partners are profit sharing or not, we said no, all not profit share. On this is the record which is available in the institute's records. Now, this complainant comes and says that we have another partnership deed of the year 2002, in which there are only 3 partners given. and they produce a photocopy of a document, which they claim is the partnership deed, which we don't admit. Before the at the first stage, we keep on asking them to give us inspection for us to make any statement. They refuse to give inspection. Then in the second stage, before the disciplinary committee, we show our 2001 partnership deed to the disciplinary committee and tell them that this is not something which is available in the institute's record, because this is not required to be uploaded by a chartered accountant. Form 18, which has to be filed when reconstituting the firm, names have to be given, many details are given, but not partnership deed. And a slight background, we were very apprehensive of giving any new documents which the other side does not have complainant, because of a background litigation concerning the will of late Priyambada Devi Pirla. The Lothas are the beneficiaries. And the complainant, in fact, before the complaint is even served on us, the full complaint details we get to know from an affidavit or an application filed in the probate proceeding, that there are charges against my client before the institute. So that is, and the records which they are producing, the complainants, suppose very many documents to basically to malign my clients, they are all verbatim, I mean, with the same to tick marks from the records of the testamentary suit and other allied proceedings, CLB company law board then. So we were very apprehensive of giving anything, because one doesn't know, they will try to dig out something and try to hurt our business. So we disclosed this partnership deed to the disciplinary committee, extensive examination of 2001 partnership deed. It is recorded in the, whatever they call it, minutes or daily recording, saying that I've got the partnership deed, I can show you. The members say, very well, show it to us, but don't give it to them. We show it to the members. Members record it. We have seen it. Disciplinary committee. Order also records. Yes, order also records that. Shown to me. So, and this 2002 deed does not surface. Then the evidence in support of the 2002 deed. Now, as I said, this, because of the Lodha Birla dispute, there are complaints made by, wherever possible, institute, company law board, labor authorities, various, wherever places, even CBI, there are complaints. Wherever one gets a scope against the other side, let me not make it partisan, one gets a complaint. So on that basis, on that complaint, so one of the fallouts of this was that these complainants of whoever informed the income tax authorities that we are relying upon a 14-partner partnership deed. Because before the income tax for one particular assessment year, we had shown the non-profit sharing partners' income as expenditure of the firm, as salaries and wages, as salaries. Because partners' share of profit in the form of fixed remuneration or fluctuating cannot be an expenditure. It is not a deductible expenditure. So we had claimed those deductions. Income tax, the same time around, opens up the proceeding. Reopens that assessment year where we had claimed this as expenditure. Income tax finds that there are actually 10 or 11 of them are not really salaried employees, but they are really non-profit sharing partners. So that particular expense is disallowed, and the income, and that is added back to my income, and I have to pay tax and penalty for that on that basis. I think to 2000.
Also records that in 2001 partnership deed there are 14.
Yes, obviously, because on the basis of 14 partners, it is. So this is also before the disciplinary committee. Disciplinary committee holds against us on the premise that on charges 1 and 4. Very interesting, because under the schedule to the Chartered Accountants Act, what is a misconduct, professional misconduct, is tabulated, and this whole case is concerning one particular professional misconduct under Part 3 of the first schedule. Lordship has the 2001 Act, I hope, or has the 1949 Act, I hope, because this was under 1949 Act.
Yes, that is also there.
Yes.
Second.
Lordship kindly comes to that schedule, the first schedule, because both the charges I am held guilty of professional misconduct under first schedule, Part 3, Para 1, Para or Clause 1. May I just place that? Otherwise, my argument will not be contextual. First schedule, Part 3, Clause 1.
31. Doctor, yes, tag there. অনেকগুলো কপি। Yes, আমার কাছে হার্ড কপি নেই।
Now, a member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he includes in any statement, return or form to be submitted to the council any particulars submitted to the council, any particulars knowing them to be false.
This is schedule, first
schedule, Part 3, Para 1.
Part 3, sorry.
First schedule, Part 3, Para 1.
Yes, yes. Yes.
First schedule, Part 3, Para 1. A member of the institute, whether a practice or not, shall be deemed to be guilty of professional misconduct if he includes in any statement, return or form to be submitted to the council any particulars knowing them to be false.
Number of partners.
Number of partners. The finding by the disciplinary committee on charge 4 is that I submitted statements, returns form to empaneling authorities, RBI, State Bank, etc., to get more audits. Under Part and held me guilty of professional misconduct under Part 3, Clause 1. Under charge 1, it is held I may have misled the institute or the empaneling authorities. Either or, income tax, whatever other empaneling authorities.
Part 1.5 was also there. First schedule, Part 1.5.
No, only first schedule, Part 3.1.
Part 3.1.
Part 3, Para 1. Nothing else.
All right.
Now, this is accepted by the so this is then referred to the council. The council accepts this decision and holds us, and the penalty is then 6 months of suspension. This is the whole case put very dryly. Now, some more important facts in this case are,
yes,
the issue comes up whether the points, this part of the, so how do they, I was more prepared for rejoinder, so starting again, it's a little, I know everything, but then it has just a recapitulation. Now, what was also held by the disciplinary council is that why am I guilty of misleading the empaneling authorities? I had 3 partners, but I'm showing 14 partners. Why? Because the partnership deed of 2001, which has 14 partners, which is in sync with my Form 18, cannot be looked into because copy was not given to the complainants. That was the finding of the disciplinary committee in one place. Another place, the finding is this 2001 partnership deed has never been disclosed to me, to the disciplinary committee at all. So how do I know about this deed? Another place, it has been submitted to the disciplinary committee, but copy not given to the complainant. This is another very crucial part because we want to stem this altogether, because there is no misleading information given to either institute or the empaneling authority. Does not come within the purview of this part 1, schedule 1, first schedule. But because firstly, my factual answer is I have shown repeat at least 3 places in the transcript of the proceeding. It is recorded that you very well show it to me. I will not give it to the other side. And this specifically, we also gave in writing that we have submitted, we had shown it to the council, to the disciplinary committee at the time of the trial, and we are willing to submit to the disciplinary committee also without giving, so long as it's secret. I mean, it is not made available to the other side. So the finding that the document was not at all submitted to the disciplinary committee, which is one of the reasons given, is factually incorrect. Second part, that given to us but not shown to the other side, factually, then that should have been made clear to us in course of the hearing, because we should have been told that I will not look at it unless you give a copy. On the contrary, the DC asks for it, looks at it. When we at each time we show it, we qualify by saying that we will not give it to the other side. So this should have been made available, but known to us. Natural justice principles. And third, but certainly not the least important point, is that as per the Chartered Accountants Act and the regulations which was placed by Mr. Anirban Rai for the institute in reply, we clearly show that the complainants are not entitled to any of the records, and this is a proceeding between, after it goes to the DC, it's clearly a proceeding between the institute and the accused chartered accountants. They have no right to get a copy under the Act and the rules and regulations. They have a right to get my written objection or written statement at the first stage before the council, when it decides whether or not to commence the discipline. Only at that stage, reply, rejoinder, everything. But once it is referred to the disciplinary committee, the complainants are not supposed to be there. If at all they are present, they will be like a de facto complainant in a criminal trial. And that the sections are clear, and Mr. Anirban Rai, the regulations which he has placed will make it even more clear. That so the whole basis of the disciplinary committee's finding against me that I have misled, I have only 3 partners, I don't have 14 partners, stands on a false premise altogether. Both factually incorrect and legally incorrect.
Because they did not produce a 2002 deed at any point of time.
Photocopy, which we have denied, strongly denied the existence of it. Original they could not produce, or they did not produce.
You asked for the original.
Repeated. There are letters.
Yes.
And where did you get it from also? Those questions that I cannot disclose. And in fact, one place I actually recall that I got it from Khaitan Company. Khaitan and Company. Was it Khaitan and Company? Eh? Yes, the complainant said. But if you got it from there, very well. But then they should have given you the original at least. And anyways, even that if at all, and the beauty of it is that Form 18 is submitted in 2021 on the basis. And in that Form 18, I couldn't have, if at all there was a deed of 2002. 2001 is the 2001 deed. Form 18, 2001. So I could not have made a misstatement in my Form 18 for a deed which came into existence in 2002. So that is a very obvious fallacy in that whole thing, if at all there was such a deed. And anyway, that deed has not seen the light of the day. Even the income tax authorities have added back the income by holding that there are 14 partners. Every empaneling authority has 14 partner deed. 2002 deed, if at all there was any deed like that, has not been disclosed to any authority. And 2014 deed is the only deed, which is only partnership deed, which is before the institute, before everybody else.
There's one.
There's one deed. Now, just a few facts I must show, my lords. Otherwise, when that 2001 deed, and yes, I must show the form first. The Form 18. Kindly come to 735B. This is the form which is required to be filed each time the firm is reconstituted. This is the form which is in issue, 735B, where according to the complaint cases that I misled the institute by giving this form. What is the date of the deed? Lordship, kindly. Same day. No, this is given in 2002, submitted. Submitted in 2000. And ours is April, and the next one is April 2000. Page number 2. Yes. Kindly first see when it was submitted, that is 735 capital E. The last page of this form, 735 capital E, is the date on which it is submitted with the rubber stamp, is 31st of January 2002. The other alleged deed is of April 2002. 1st April 2002. Now coming back to 735B. Kindly see entry under 3B entry. 3B, date on which the partnership was entered into, 31st December 2001.
That was the date of the 2001 deed.
2001.
Obviously, that was. Yes.
So we filed this within a month of the 2001 deed. And Lordship, kindly see 3D, because whether all the partners are sharing the profits of the firm. Answer is no. And the names are given.
You had also insinuated that a deed is not required for registration of a partnership, but to that, Mr. Rai said that you had said yes.
I had said yes.
In C, and you said that 2001 was produced, and the circumstances have given his lordship.
Yes.
That you didn't want to disclose it to the other side because of these reasons, which you have already argued today.
Yes. So this is the deed which is in question. So what should have been an issue as per that part 3, clause 1, is that whether I made any misstatement by submitting this form. This is the only germane issue so far as the document submitted, return submitted to the institute. Now, this goes away from. Now, this deed was shown to the disciplinary committee on a number of occasions. Lordship kindly comes to the minutes. In the meantime, you take out where we asked him to produce the original. Where we had asked. when the hearing started. Ashok kindly comes to page 353. Oh, yes, you got it. 353 is before the disciplinary committee. Ashok kindly see 352. 352. In third para, Sri A.V. Lodha, 352. First of Sri A.V. Lodha, 352, third para. First of all, I want to say that Form 18, which has been filed with the Institute, is absolutely correct. This is my first submission, and the second submission is that the same complaint was filed with the CAG. The same complaint was filed. All this happened same time. I have no evidence to show. I will show you that the letter which has been received. We went there and submitted our response. CAG examined it as an independent body. They continues to give us grade A audit. Now, last paragraph. G. Ramaswamy, that is the disciplinary committee member. That is why they want to substantiate the claim. Form 18 filed with the institute is correct. You agreed, but the same information is not filed with the other departments. You have to explain that. Based on the evidences, this again they are veering away from that. They have produced. You have given different partners names with income tax department. Correct, but that I have to pay the price for it. That is the point. They are rising so that means deliberately they are raising. So that you mean deliberately you have given one evidence to the department and one evidence to the institute. So this is the point which they want to come out. There is a wrong declaration, and with respect to this, the income tax department, whatever documents they have produced, you have questioned this legal evidence. Apart from this legal, now kindly come to the next page. 353, the fifth line.
Mr. Mitra, only one question. Before the income tax department, you said that you had shown their incomes as expenditure. Did you specifically state anywhere before the income tax department that there are three partners?
Three partners' incomes are given. The withdrawals
by default, because if you show those as expenditure, then three partners' incomes. Very.
We are not required to say how many partners we have.
No, you're not exactly. That is what. Very.
353, the bold. The original documents produced by the respondents before the committee with the request that these documents cannot be parted with the complainants. The same was returned back after going through the committee. Now, Lordship, as you scroll down, where is the president puts a question, where is the copy of the deed of partnership?
We look down, you scroll down.
Yes. Partnership, this is the one I said earlier, Mr. Mukherjee responsible for me to scroll down. Otherwise, I would have also looked down. So he has to be there with me to assist me.
But don't look down upon. It stops there. Down.
Where is the copy of the deed of partnership? Partnership deed produced by the respondent A.V. Lodha before the committee. Now, just apropos this, kindly see page 550. Page 550, there is the disciplinary committee's finding. Same volume, 550. Paragraph 62 at 550. Charge 4, it was said is produced. Charges against charge 1, 550, para 62. The committee asked the respondents to produce evidence showing that the allegation made in the said alleged matter are similar with the cases filed with the different authorities, the CAG and RBI, with some motive. In this regard, the respondent requested the committee members that they could produce the same, but those documents would not be parted with the complainants. respondents produce the documents, including the copy of the partnership deed before the committee, and the same was returned back to respondents after perusal of the document. This is where it said that we had produced it.
Yes.
Now, if you kindly come to
54.12.
oh yes, just the opposite finding. This is at 546,
546.
page 546.
4 pages before.
4 pages
While
before.
deciding charge 1.
While deciding charge 1, yes, while this is because charge 4 starts from page 549. Charge 1 ends at 546. Kindly come to 54.12. The 54.12, the respondents could not produce any partnership deed in support of their contention in Form 18 under the serial number 3C. That is whether the partnership deed is supported by a deed, to which the answer was yes. Just the opposite. Charge 1, it is not produced. Charge 4, it was produced but not shown.
At page 550, it's recorded you produce a copy. You also produced a copy of the partnership.
Yes.
Although at 353, it's recorded partnership deed produced, but 550 says you produced a copy.
Yes, Lordship, right. Lordship is right.
Anyway.
The deed was, I do not remember. I was there at the time, whether the
copy.
original deed was produced or the.
Because you take a point that they have produced a copy. That's why you are putting this question to you.
But because we had doubted, we had asked for them to produce the original. Here,
during the proceeding, we had shown the original.
oh, yes, 531. Kindly come to 531.
And 353 also it's written
Original.
Partnership deed.
Partnership deed. Now, kindly see 531. That is part of charge 1. Yes, yes. Yes, that is charge 1 starts at 524. Kindly come to 531. Last 7 lines of paragraph 45. Last 7 lines of the page.
Yes, original. It's written. I have shown the original, right?
So,
original documents only.
yes, 353, the my lord saw it.
Yes, 353 is there.
My lord is
coupled with. It's more explicit, original. The partnership deed was partnership deed. Yes. Anyway, very good.
Now, Lordship, kindly come to the findings straight away before I. Against charge 1, the finding is
546. Oh, the findings.
No, may I just show you, Lordship?
Finding 539.
539 it starts. Para 54, Lordship, the relevant part, 539.
Yes.
See other note lekha hai.
Now, Lordship, kindly come to the relevant part is 54.13. That is page 546. 54.12 and 54.13. 54.12 is 546, which I showed could not produce, and 54.13 is what is the ratio. In view of the aforesaid, the committee is of the considered opinion that the respondents are responsible for filing false particulars of partnership of Messrs. Lodha and Company, Mumbai. In view of above, the committee wishes to point out that the respondents have either filed false particulars with the institute and impaneling authorities, or furnished false particulars with the tax authorities. This is a mens rea. This is I'm sure this is a furnished particulars, false particulars with the tax authorities to claim salary of partners as expense and to save tax. This is an act unbecoming of a chartered accountant.
Guilty.
So, accordingly, the committee is of the opinion that the respondents are guilty of professional misconduct.
That leeway is probably given in the main section.
Well,
in the main section, in the parts in the schedule, that leeway is not there, unbecoming of a chartered accountant. But in the main section,
in the main section that I will show that anyways, if at all, I mean, unbecoming, the word is not there.
No, not
but
there.
Then
yes,
this is why
other
that is high cost domain, because the The council is only first schedule, part 1, part 3. That is High Court. So that can anyway not form a part of this proceeding. That will be my counter to the argument that section 22 of Mr. Kaur and Mr. Ray may not be wider, but then that is not the council's domain. And also that apart, that's the legal part. Charge is very clear. Under part, I am charging you with an offense under first schedule, part 3, clause 1. Now you cannot then go away from that charge and go into unbecoming conduct. But anyway, they couldn't have. Now Lordship kindly comes to the findings on charge 4, which is on the same documents. Charge 4 starts at 549. The findings are 551. There it was said, the either or.
Yes.
Para 63. The committee has carefully considered submission 63.1. Now here it becomes only 1. Admittedly, the respondents and their firms have filed some particulars with the impaneling authorities, which they have filed with the institute in Form 18. The respondents have and their firms have filed same particulars with the impaneling authorities, which they filed with the institute in Form 18. In view of the finding, the committee is of the opinion that the respondents have filed false particulars with the impaneling authorities. 2.
Yes.
And the charge 63.3, in view of the above, the opinion of the committee, the respondents are guilty of professional misconduct in terms of clause 1 of part 3 of the first schedule, the chartered accountant, read with 2122.
File submitted with this.
Submit. Now, kindly see the act once. What comes within the domain of the institute and what comes within the domain of the council and what part. Dr. Section 22 and 20. Yes.
22 is defined. What definition?
22 and 21. That other 22 kindly takes a look. Professional misconduct defined. For the purposes of this act, the expression professional misconduct shall be deemed to include any act or omission specified in any of the schedules, but nothing in this section shall be construed to limit or abridge in any way the power conferred or duty cast on chartered accountant under subsection 1 of section 21 to inquire into the conduct of any member of the institute under any other circumstances.
So then this power is given to the council.
Now kindly come, they may inquire, but they can't give any conviction. They have to come. Logically comes to section 21. 21, subsection 1 is the first stage, where on receipt of information by or of a complaint made to it, the council is prima facie of opinion any member of the institute has been guilty of any professional or other misconduct. The council shall refer the case to the disciplinary committee. The disciplinary committee shall thereupon hold such inquiry in such manner as may be prescribed and shall report the result of its inquiry to the council. May I jump and come to subsection 4, where the finding is that a member of the institute has been guilty of a professional misconduct specified in the first schedule. The council shall afford to the member an opportunity of being heard before orders are passed against him on the case and may thereafter make any of the following orders: reprimand, remove not exceeding 5 years. So if the misconduct is specified in the first schedule, now proviso. Provided that where it appears to the council that the case is one in which the name of the member ought to be removed from the register for a period exceeding 5 years or permanently, it shall not make any order referred to in clause 1 of A or B that shall forward the case to the High Court with its recommendation.
Actually, 5 is more. 5.
Where the misconduct in respect of which the council has found any member misconduct and other than any such misconduct as referred to in subsection.
4 refers to Schedule 1 and
So
other
as I'm
this-
saying, so if this could have been unbecoming, could have been that the institute should have then, I mean, the council should have then referred to High Court and not given a sentence on that.
Yes.
After hearing the other side, it becomes a little more simpler. Now coming
Cut short time on further rejoinder by.
Yes,
Because already they have discussed.
unless they say something new. Of course, their judgments are galore, so those also have to distinguish. Now, Lordship kindly comes to my to the other part of my submission.
Yes.
Though nothing really turns.
ফাইন্ডিংটাও আছে একবার দেখিয়ে দেবেন যে
কি?
আমরা ডকুমেন্ট দিইনি বলে 2001 ডিটটা ওদের ওয়েবসাইটকে দিইনি তাই জন্য ওটা
Yes,
কনসিডার করছে না
Lordship, may I just show that whether though that's not relevant because if I have given wrong form or wrong statement to the institute
54.7
at the disciplinary committee stage, whether we give it to the other side or not, the institute has to be satisfied whether
You are saying that Mr. Ray produced a regulation.
regulations which
You can cite that also and argue on
course,
that also.
of course.
But in whichever way you like. I mean,
I will show it from that, but then
you can
just
touch
show-
that also so that it cuts short the time of further rejoinder. Yes.
4.7 fine
just can you see page 544 once, page 50, paragraph 54.7 as a prelude to this part of my argument.
Yes.
Page 544, 54.7.
Yes.
It is neither possible, so because apropos this, I'll come to Mr. Ray's submission. It is neither possible nor justified to place reliance on the documents shown to the disciplinary committee by the respondents during the course of the proceedings. None of the documents or any copy thereof were filed either before the council or the committee. Neither any opportunity was given to the complainants to offer their arguments on such documents. So, apropos this, Balan, may I just come straight away to the regulations.
Regulation টা দেখো তো কিছু। এটা
The
respondent-
regulations,
respondent
chartered accountants
Okay.
regulations.
Respondent আছে, হ্যাঁ। এই জন্যই তো। Yes. অনির্বাণের জন্য অনির্বাণ কেটে দেওয়া appeal করে।
চার্টার্ড অ্যাকাউন্ট ওইটা নতুন অ্যাক্ট ওই অ্যাক্টে কিছু পাবে না নতুন অ্যাক্টে সব পুরো চেঞ্জ হয়ে গেছে ওইটাতে নতুন আছে
That's the new act, 2021 act. The book.
টু অ্যামেন্ডমেন্টসও আছে
Application টা 2022 তে। Or 2014 1914 কিন্তু ঘটনাটা ঘটেছে তো আপনার 2001 সালে। এটা 2022 এর অ্যামেন্ডমেন্ট আছে। 22 অ্যামেন্ডমেন্টে এটা ঢুকিয়েছে। আগেরটা এটাই ফলো করুন। আপনি এটা ফলো করুন ব্লাইন্ডলি, হ্যাঁ। Yes.
Well, before I come to regulation, the statute also makes it clear that at the disciplinary committee stage, council stage, they are possibly I am the only person to be heard. 21 subsection 4 and 21 subsection 4 and 20. The first sentence, where the finding is that a member of the institute has been guilty of a professional misconduct specified in the first schedule, the council shall afford to the member an opportunity of being heard. Member an opportunity of being heard before orders are passed. Now, also,
22A তখন হাইকোর্টে আসবে তখন দে ডোন্ট গেট আ রাইট
22A. I mean, now, where we are today, 22. Any member of the institute aggrieved by any order of the council imposing on him by way of penalties referred to subsection 4 of section 21 may within 30 days of the date on which order is communicated prefer an appeal, provided that the High Court may entertain any such appeal after expiry. Now, subsection 2, the High Court may on its own motion or otherwise after calling for the records revise any order and may confirm order. The proviso to that pass, provided that no order of the council shall be modified or set aside unless the council has been given an opportunity of being heard. Council has been given and no order.
And that is not real.
So now also their presence is really not a statutorily required presence. And this will become clearer from the regulations. What was placed by Mr. Ray's regulation 12, that is in fact the most important regulation. So should I start with this next year because it is now 1:14?
Yes, they can.
This will take me 10 minutes.
Let me have your
Order. We heard in part for further hearing on December 3, 2020.
May I have your lordship's leave to mention item 26 of your lordship's list, my lord.
Yes.
You need to file the corrected version of the paper book, my lord. It's an appeal. So, my lords, we have your lordship's leave to file the paper book now, or my lords,
When it is taken up.
when it is taken.
Yes, yes, absolutely.
The other side was here, my lord.
Yes, I am.
File it when the matter is taken up. It will be easier for the office to maintain the records also.
Lordship, item 28 may permit file paper today. Just
No, whenever the matter is taken up, you file it.
okay.
Yes. এগুলো Yes.
But with some degree of impertinence, especially assigned matters, which is appearing, I think today 104, 105 and 106.
Yes.
But earlier, your lordship would indicate as to when these would be taken up.
Oh,
That's the only.
Thank you for reminding.
I was scared that your lordship will get angry.
No, thank you for reminding.
I was
My fault. I forgot. এক মিনিট শুনুন বলছি যে অ্যাসাইনমেন্ট একটা আগে Tuesdays, yes.
The same your lordship used to have.
Yes.
Yes.
My lord,
Very
may I
good.
permit to mention one matter? My lord, this is COLRT for inclusion, my lord,
Handle.
for expeditious, yes.
May I refer me to mention, my lord, applications in first appeal. The
Yes.
appeal is yet to be heard.
May I permit to mention, my lord, this is pertaining to a first appeal, my lord, where there is a direction upon the special messenger to brought the lower court records, my lord.
Yes.
However, as along with the lower court records, there is a miss case pending, which record has also been brought down before this court, since the lower court cannot proceed, the trial court cannot proceed with the matter. I am humbly beseeching your lordship, if that particular records
Give a notice to the other side, it will appear as to be mentioned.
My lord, I
It will
mentioned.
appear as to be mentioned.
Great.
As soon as the file comes, it will appear as to be mentioned. Yes.
Mentioning two applications, my lord, in connection with the first.
Please.
So, sir, I'm mentioning an application in connection with the
Yes.
first appeal. This is for release, your lordship, for releasing
Then
the
it will appear
matter.
as to be mentioned, right to be mentioned, not application, right to be mentioned within bracket for release. Yes.
My lord, only for correction, Mr. Arindam Banerjee.
To be mentioned for correction.
His name is recorded as Mr. Arindam Mukherjee, man. So that's
Very good. আচ্ছা তো এটা আপলোড হয়নি তো ভুলটা তাহলে এখানে কিছুই করে দেবো নাকি এটা থেকে পুরো কেটে দিতে হবে দুজনেই কেটে দিতে হবে এরম হলে তুমি আগে থেকে ওকে বলে রাখবে ঝট করে ওয়ান রেখে দিলে তারপরে খারাপ দেখায় বলে রাখবে যে হয়ে যাওয়ার পর মেনশন মানে দেবো ওই একটা ডেটে ভুলে গেছিল এই জন্য এই Yes. Why to be mentioned? Oh, some correction is required. We had there's a typographical error in the previous order, so we are correcting that. Right. In the order dated November 18, 2025, comma, can 1 of 2023 was erroneously transcribed as can 1 of 2025. Full stop. Accordingly, let it be deemed that in the caption of the order, said order, comma, can 1 of 2025 is to be read as can 1 of 2023. Thank you. Thank you. Yes, Mr. Ghosh, what is the matter?
There are two defects I found in the.
What are the defects?
Firstly, the defect in the appeal court decree, where the name of the defendant number 4 and 5.
Yes.
Was not there.
5 and 6.
5 and 6. I'm sorry.
Trial court do not. Yes. What about that?
Regarding defendant number 6, he died during the pendency of the appeal. That's why his name was
heirs were substituted.
Heirs are the plaintiff, the defendant number 1.
Very well.
The plaintiff is the heir, and the pro forma is the defendant number.
So they have not been mentioned in the memo.
No.
The heirs have. Oh, acha, the heirs are all.
And the regarding the defendant number 5.
3, yes.
She is the unmarried daughter of the defendant number 1.
Now, first name of the appellant number 3 in the cause title.
It should be Dipen, D-I-P-E-N. It was written D-I-P-A-N.
So we'll give you leave to correct that.
Yes, correct.
And the other one, it has to go down. So we'll direct that, but first we'll hear it turned out of it. Acha, leave is granted to the learned advocate on record for the appellants to carry out the necessary rectification in the name of appellant number 3 in the memorandum of appeal during the course of the day. First up, the records be the decree of the appellate court of the trial court. No, the appellate court decree should be sent down then.
Yes.
The decree of the appellate court be sent down for the purpose of necessary correction, since it is submitted by learned counsel for the appellants that There are two defendants whose name on
Defendant
this.
number 6 is the pro forma defendant, was the pro forma defendant. He died.
And 5?
At 5 was the unmarried daughter of the defendant number 1. Subsequently, he got married and she left the residential. This is regarding suit
But
for.
has to be a party in the appellate court.
That is, he was not party in the appeal court also, with the learned appeal court also, first appellate court also. He was party in the suit, but he was not. She was not
Effective
party.
necessary corrections in the appellate court's decree. But if she was not a party in the appeal,
she should be party as a pro forma respondent at least.
then we will give you that liberty also.
Can you allow me to that?
সেকেন্ডটা যেটা রইলো প্রথমটা যেটা করলাম to effect necessary correction in the name of appellant number 3 as well as incorporating the name of the defendant number 5 as pro forma respondent in the cause title of the memorandum of appeal during the course of the day. Carry out the corrections during the course of the day, even if you dismiss your appeal, even then. Yes.
Now, this is a suit for eviction of trespasser and recovery of khas position.
You are the?
I am the defendant.
Lost in both courts?
Lost in both courts.
Achha. What is your case?
The admitted fact is that the defendants were permitted by the pro forma defendant number 6, who has subsequently died, to reside in the said land, thereby constructing a mud house. Now, I was residing. When I was residing in 2008, the pro forma defendant number 6 gifted the entire property to the plaintiff. Now, I was not informed about that fact. Now, subsequently, the pro forma defendant number 6 in 2006, when he was in possession, actual ownership of the property, he made a Ghoshana Patra, thereby they declared that I will be there in the property till my death or till my age. Thereafter 2017, the suit filed. I took out the case of the adverse position, as well as I came out with the Ghoshana Patra, the Exhibit A. Learned trial court did not frame any issue on the point of lordship the adverse position. And regarding the Exhibit A, both the learned trial court was held. Since it is not a registered document, no lordship the evidential value can be given to that.
The declaration has been annexed here.
Well, that is not annexed.
Could have annexed that. Where is that? Copy of that? Without that, it's a concurrent finding of both the courts. How can you differ?
Yes, but may I show the
document is there?
No, document is not with me. It is an original document of the court. May I show that?
Could be with your advocate there. The declaration was what? That?
Declaration of position.
What is the finding of the appeal court?
No, Lord, may I show to your lordship? Will kindly come to inner page 19.
19?
19. Inner page 19 of the appeal court order.
Achha. There is no inner page 19. 16 is the last page.
Madam.
It was marked as an exhibit.
The document? Yes.
Which exhibit?
Exhibit A. No, Malad, kindly come. May I show to you? So I'm sorry, Malad.
Ghoshana Patra.
Kindly come to the trial court order. Inner page.
The appeal court first.
I'm not sure also the document which was marked.
No, page 8 of the appeal court. We are there. It is merged in the appeal court. So
yes, Malad, kindly come to page 12, paragraph 9.
No, page 8 first. He has submitted. Let us read it. Yes. Ghoshana Patra exhibit. Page 12.
Page 12, Malad. Paragraph 19.
Right.
May I read for you?
Who is Chittaranjan Maiti?
The DW2.
Your client, yes. One of your, yes.
But his signature in the exhibit A was not exhibited. From his adduce, it appears that he knows Adhor Chandra Das, who used to travel on the bus when he was working as a bus conductor, but he failed to say the date on which he joined as a bus conductor, where he worked for 35 years. He has stated that Adhor Chandra Das had a house on plot number 1105. He has also stated that he has a part in the conversation between Adhor Chandra Das and the Gauri Shankar Das. Have 3 times taken place at the house of the Adhor Chandra Das, but he failed to produce any document in support of his contention. He has admitted that he had never been a party of any conversation between Gauri Shankar Das and Adhor Chandra Das regarding the sale and purchase of landed property. Exhibit A was produced by DW1, which bears the signature allegedly of Adhor Chandra Das, but there is no signature of the person in whose favor it was executed. On reading of this declaration, Ghoshanapatri reveals that he has declared Dipen Das and Dinesh Das as a Borgatar in respect of Dosha land and transfer of possession of the said land in respect of plot number 1104 and 104, for the construction of the house. Notably, this document does not bear any stamp, which is required as per the Stamp Act and Registration Act. This document was a document required to be impounded by the Land Trial Court, did not consider the same. But such document without any stamp, no transfer of possession or interest can be made as per law. The said document can never be admitted as evidence. Well, this document was never challenged by the plaintiff. It was
need not be challenged. It's evidentiary value. And where is the trial court finding on this?
My lord, may I? On page 13. My lord, kindly come to page 13. The second paragraph start from.
Yes. I have gone
through the Ghoshanapatra dated 20 June 2006, which has been marked as Exhibit A, wherein it can be ascertained that the father of the plaintiff had given permission to the defendant to
This was a permissive permission, permission given.
Permission given.
So by your licensee then eviction suit, by filing eviction suit, that is sufficient. No notice is required to be given to you.
No, notice was given to me after giving notice.
At best, you were a permissive occupier.
No, thereafter, it was given to us.
Yes.
I claim an adverse position because he subsequently.
See, on both grounds, adverse position and license are diametrically opposite to each other.
Yes, my lord.
Mutually destructive. So on that ground itself, your defense should have been struck. I mean, your case should not should have been disbelieved. One. Secondly, this permissive at best position permission to stay there was given to you, which is you are evictable by filing a suit only.
Subject to correction.
So no right has been created.
2008, the Adhor Chandra transferred the property to the plaintiff.
Not yes.
To the plaintiff.
Yes. Plaintiffs are owners.
Plaintiffs to her daughter.
Yes.
His daughter. Number 2000 after 2008.
Yes.
Subject to correction. I came into an adverse position because license is given by the Adhor Chandra Das.
Adverse position has to be pleaded and proved. What is your written statement?
It's in my application.
No, written statement, yes.
In my application, it's annexed.
Yes, right. What is the pleading of adverse position?
My lord, may I show to your lordship? My lord, kindly come to page 26. Paragraph 50.
Paragraph?
50.
Paragraph 50.
Page 19, 26, paragraph 50, written statement in my application.
Page 19, the written statement starts.
Page 26, 36. Page 36, paragraph
36.
Page 36, paragraph 50. Here I stated.
But the difficulty, Mr. Ghosh, is just if at your entry point you were a licensee, permissive occupier.
I cannot my case. This is the fact. At the entry point, I was licensed. And in the record of rights, my name has been recorded as Onumati Dong.
Then
it is admitted.
Sorry. The present appeal has been preferred.
I'll only pay one thing. Kindly give me some time so that I can leave.
Pay before the executing court. The present
that leave may be granted.
The present second appeal has been preferred by the defendant in a suit for eviction of trespasser, which of both the courts below have concurrently found that the defendant is a trespasser. Declaration, a purported declaration, was furnished by the appellant in evidence in the appellants in the courts below, which was marked as Exhibit A, which indicated that the predecessor in interest of the plaintiff / respondent granted permissive possession to the appellants. Next para, both the courts below have proceeded on the premise that such declaration, being unstamped and unregistered, did not confer any title on the appellants. Moreover, we are of the opinion that even if such permissive possession was given, comma, the filing of the suit itself is sufficient to get an eviction decree against a licensee stroke permissive occupier. So next para, the defendants also ran a case of adverse possession after the demise of the predecessor in interest of the plaintiff, who allegedly granted license in favor of the appellants. However, comma, since the appellants claim permissive possession at the entry point to the suit premises, comma, such possession could not have been pleaded to have been converted automatically to adverse possession, comma, particularly in the absence of specific pleadings and proof in that regard. Next para, that apart, comma, we find that the defenses of adverse possession and permissive occupation are mutually destructive of each other, and as such, comma, the defendants stroke appellants failed to establish their title to the property and or legal right to occupy the same. Accordingly, we do not find any justification to interfere with the concurrent findings of both the courts below. Next para, moreover, in view of the above, comma, no substantial question of law is involved. Accordingly, SAT 267 of 2024 is dismissed under order for Rule 11 of the Code of Civil Procedure. Can 1 of 2024 is also dismissed consequentially. There will be no order as to costs. Next para, at this juncture, learned counsel for the appellants seeks some time for the appellants to vacate the suit premises. Leave is given to the appellants to make such prayer before the executing court as and when execution is levied by the plaintiff stroke respondent.
Much grateful.
Thank you.
Election করতে হবে।
Item number 3. Mr. Tanmay Mukherjee is appearing for the appellants. He is engaged in courtroom number 6.
No ground. You start the matter.
I am not engaged in this matter.
Your Lordship,
They will dismiss
Your
your
Lordship, I am appearing on behalf of the respondent. There's one difficulty, Your Lordship.
You have no right of hearing at this stage.
Right, no right of hearing. I'm not submitting on merits, Your Lordship. Only in the before the learned trial court, Mr. Srikanto Bhattacharya.
Thank you.
This matter, Your Lordship.
For your
for plaintiff side.
It is submitted by learned counsel for the respondent that the relatives of one of us, within bracket Shobhusachi Bhattacharya J, appeared on behalf of the said respondent in the trial court. Accordingly, let the matter stand released on personal ground with liberty to the parties to mention for assignment before a different bench. Thank you for mentioning. Baba. Next.
Lordship, I am for the plaintiff landlord appellant.
Right.
Lordship, suit for eviction on the various ground.
No defect.
No, Lordship.
You should be admitted on that ground only. What is the matter? Both courts lost.
No, Lordship.
What is
I won in the first court and the learned suit for eviction on the various grounds, and it was decreed mainly on two grounds: grounds of subletting and grounds of reasonable requirement.
Why reversed?
Reversed, Lordship. On the ground of subletting, the first appellate court said that there is no question of subletting, and on the ground of reasonable requirement, the first appellate court held that I have the requirement, but as there is no specific requirement, as per the
was the finding.
Lordship, kindly come to at first.
Subletting first.
Starts from page 35.
Come to the relevant page.
Relevant
not
portion.
Refer to the internal pages. We are looking at the memo.
Lordship.
Internal pagination is at the top. So appeal court just was.
Lordship, appeal court judgment, page 36, para 4.
Again, page 36.
No, Lordship, it is the judgment, so there is no internal page marking.
What are you saying? There is no running page marking. Internal page marking is at the top of the page. What are you saying?
Lordship, I am sorry, Lordship.
Sorry, Lordship.
Lordship, kindly come to internal page 6,
yes,
middle part.
Yes.
Jagadish Prasad Chawla, that is the defendant. Jagadish Prasad Chawla are living separately and runs their livelihood separately. Then no resumption can be drawn that in spite of having father and son relationship, the defendant is doing wrongful act by putting his son in his business without the authority of the landlord. In the present suit, from the surrounding facts and circumstances, in my understanding, when Mahendra Kumar Chawla, that is the son of the defendant, is running the business from the shoot shop room for the livelihood of their family, in no way it can be said that the defendant parting with the possession sublet the shoot property to the third party. It is no doubt that the rent receipt has been issued in favor of Jagadish Prasad Chawla by the plaintiff.
But his son is a family member.
Lordship, I will show Lordships that the
So-
son is living separately. That is Lordship, for who is the Order 41 Rule 27 application I have filed, that is Can 2.
This is for a commercial purpose, for running business.
Lordship.
Living separately does family business.
Now, Lordship, in this respect, kindly come to the finding of the learned trial court.
Yes.
Lordship, page 36, para 4.
Make him understand what you're going to say.
Page number mention kara. Page number, page number nahi.
In fact, there is the page number in the trial code.
Lordship, that is the problem.
Yes, read, you will catch up.
Lordship,
Issue number
admitted-
4, under issue number 4. Issue number 4 is subletting.
Lordship, admittedly, the defendant is the tenant under the plaintiff. No rent receipt has been issued in the name of JPS Chawla and company by the plaintiff. Lordship, I have issued rent receipt.
Father.
Father. But that is the JPS Chawla and company. Kindly mark it.
No, your tenant is the father, not company.
No, my tenant is not the company. And Lordship, kindly, thus from the evidence of PW1, it is proved that the defendant has.
Is it a company?
Lordship,
Name may be company, but is it
no, Lordship,
incorporated?
shoe manufacturing and
Yes,
trading.
it may be a proprietorship business may also be called a company. The nomenclature may be company. It often happens.
But Lordship, the rent receipt is the name of father, known in the name of company. Thus, from the evidence of PW1, it is proved that the defendant has sublet the tenancy in favor of JPS Chawla and company without taking any written consent from the landlord. It has been admitted by DW1 in his cross-examination that JPS Chawla runs business from 3 rooms, 2 rooms in the ground floor and 1 room in the first floor. Next page, Lordships. DW1 admitted in his cross-examination that he does not have any trade license in his name. I perused Exhibit 13. It appears therefrom that the electricity bill is in the name of Messrs. JPS Chawla Footwear and consumer type is commercial. DW1 admitted in his cross-examination that he does not have any written permission from landlord, either erstwhile or present landlord, for taking electric meter in his name. It necessarily follows therefrom that the defendant has done illegal act without obtaining any permission from the landlord. It has further been admitted by DW1 that he resides in 4D Madan Mitra Lane, which is his own house, Lordship. Thus, from the evidence of DW1, it is proved that the defendant has parted with possession of the shoot room in favor of a third party, namely JPS Chawla Footwear. Thus, the fact of sublet.
We have seen that. Come to the appellate court for the reasonable requirement.
Lordship.
Internal page 7.
Lordship.
Page 7, we continue at 8. Now, it has been observed by the appellate court that you suppressed that you had obtained several rooms in the suit.
No, Lordship. Lordship, for which I have filed the Order 41 Rule 27 application.
What is there in that?
Lordship, Can 2.
What is there? What do you want to
Lordship,
produce?
the commissioner's report.
What does it say? You had a commission work regarding the suit building also.
Lordship.
What was said by the commissioner?
Commissioner says that there is every room is tenanted room. I have not got any possession of in respect of any room.
So why are you producing Order 41 27? That was not a part, not exhibited in the trial court.
No, Lordship. My other side had filed an application under Order 41 Rule 27 in the appellate court. And Lordship, I have filed some more documents, especially this order.
Commission work was not held in the trial court. During the suit, you did not.
Lordship, commission was held in respect of another suit. Lordship, there are several tenants in the building. Almost all of the rooms are tenanted rooms, and commission work was held in respect of the other suits. And in that commission's report, this room has also been.
Why didn't you have it exhibited in this suit also?
Lordship, before that, my suit was the order of the trial court was set aside. I did not get the chance.
What was the order for 27 of the other side in the appellate court?
Lordship, the deposition of PW1 and DW1.
BW1 and DW1 are a part of the record. Why order for 27?
I don't know why they have filed that order for.
That is immaterial. We are on your case only.
Other case. হ্যাঁ বলেছি তো other case. Another case. আরে বলেছি lordship কে সেটা. Another cases. Lordship, that is immaterial in this respect. For which lordship, I have filed this order 41 rule 27 application before your lordships to prove that every rule.
But the suits being taken up together.
Lordships.
No, not analogously.
Lordship, kindly pass an order of direction to serve me the copy of the other side because.
No question of service unless we are satisfied on order for 2011. In this suit, you had not asked for any local inspection, and neither had you produced that the other local inspection report in this suit. Why?
Lordship, it was decreed, and I put the decree into execution.
Even before the appellate court, you did not produce that document by way of order for 27. Why should the in second appeal we allow it for the first time?
এটা দেয়া হয়নি কেন? ওইটা পরে হয়েছে, কোর্টের অর্ডারে হয়েছে। তো ওইটা আমরা রেন্টেড প্রিমিসেস সেটা মেনে নিয়েছে রেন্টেড প্রিমিসেস
সাবলেটিংটা ইয়ে রয়েছে
রেন্টেড প্রিমিসেস
কোম্পানিকে দিয়েছে
ওটা ল্যান্ডলর্ড, তাই ওটা করা হয়নি এবং ও মেনেও নিয়েছে রেন্টেড প্রিমিসেস আগে।
কিন্তু আন্দাজ
কোনোদিন ডিনাই করে না যে আমাদের এখানে শুধুমাত্র ইয়ে আছে। হ্যাঁ ওইটা
ঠিক একই বিল্ডিং এ আরো অনেক টেনেন্টের বিরুদ্ধে মামলা করেছে, সেটা রেলেভেন্ট সেটা। This appeal will be heard on the following substantial questions of law. 1. Whether the learned first appellate judge substantially erred in law in overlooking the evidence to the effect that the defendant stroke respondent had permitted a shoe business to be run in the name of a company, and that the trade license for such business was not in the name of the defendants, comma, in coming to the conclusion that the plaintiff's appellant have failed to prove their case of subletting, his case of subletting. Roman 2, whether the learned first appellate court substantially erred in law in reversing the finding of the learned trial judge to the effect that the petitioner, the plaintiff stroke appellant has reasonable requirement for the suit premises on the basis of the possession of other rooms of the plaintiff stroke appellant in the suit building having been suppressed, comma, by overlooking the fact that in a different suit for eviction of a different tenant, comma, although in respect of the same suit building, comma, an inspection had been held from where it was found, from where it is seen that all the other rooms in the suit building are tenanted and, comma, as such, comma, cannot tantamount to the plaintiff stroke appellant having sufficient alternative accommodation. Roman 3, whether in view of the additional documents sought to be produced under order 14 rule 27 of the Code of Civil Procedure before this court, comma, the appellate court ought to the commissioner's report filed in a different suit in connection with the same suit building ought to be admitted in evidence, and consequentially the decree passed by the trial court on the ground of reasonable requirement ought to be sustained. Prepare your paperbooks and all.
Lord,
no question of
more humble submission.
Yes.
Lordship, your appellant is 76 years old, and there are as several litigations going on. My learned friend appearing in the first appellate court, he is taking advantage the judgment of this judgment, and he is trying to taking advantage. So kindly, Lordship.
No, you admitted the appeal, that is sufficient. There is no scope of stay of dismissal of a suit.
No, Lordship. Lordship, as there are 8 suits going on already.
So what do you want us to do?
And Lordship, in almost every suits there are appeal.
What is this application giving protection of keeping kept in abeyance of a, what is this ejectment?
We already put the cost of the police help, and this is the application for keeping abeyance of that application.
What sort of application is this? Can we keep it in abeyance? Whatever is the legal effect will follow. We have just admitted the appeal. Can 1 of 2025 is an application for keeping in abeyance the ejectment execution case filed on the premise of the trial court's decree, which has been upset by the appellate court. Full stop, next para. However, comma, there is no scope of passing such an order within the limited context of the present second appeal. Full stop, accordingly, can 1 of 2025 is disposed of without passing any order thereon. Full stop, next para. Is disposed of in the light of the above observations. Can 2 of 2025 is an application for production of additional evidence, and comma, by its very nature, comma, is required to be heard along with the appeal. Full stop, accordingly, can 2 of 2025 shall be listed along with the final hearing of the appeal. Full stop, affidavits, if any, shall be exchanged in the meantime. The appellant shall serve a copy of can 2 of 2025 along with a copy of the memorandum of appeal on the respondent, indicating and file an affidavit of service when when can 2 of 2025 is next taken up for hearing. So next para, the trial court records, the appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent within a week from date. Trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the appellant to liberty to the parties to mention the appeal for enlistment, comma, upon the same being made ready, comma, before the appropriate learned single judge having determination. Next.
I am for the petitioner.
Yes, Mr. Ghosh, what is the matter?
This is I prayed before the Revenue Authority for correction my record of rights in terms of the civil court judgment and degree. That application was filed before the DL and LRO concern. DL and LRO concern directed the BLRO. Some information or query sought for. This process was going.
Can you go directly before the DLLR for correction of the records of rights?
I filed an application, DLRO forwarded this application to the BLRO concern and sought for some information for disposal of the same and directed.
We ask you whether you can file the application before the DLLR at the first instance.
No.
You did that.
Now kindly comes to what, but in the instant.
Sought for a report, then what happened?
BLRO, DLNLO directed the BLRO to correct this record. And as per law,
directed.
Yes, that communication is there.
Then
several communication is there, but
and what happened?
Now, since the matter is the pending before the end of the BL and LRO, but not forwarding the requisites information to the DL and LRO.
For the inaction, you filed.
I filed an application before the land tribunal.
What has been
now on 23rd September was the date fixed before the land tribunal.
11th of August 26.
23 the severe water logging.
It has been fixed on 11th August 2026.
Yes, on that day, due to severe water logging, I could not reach. Adjournment was paid for. That against that inaction,
1 year after, we'll dispose of the tribunal application as well as this application. Direct the BLR. What will be a reasonable time? You tell us, Mr. Yes,
within 3 months.
Thank you very much. For this, we asked you because you will give a fair answer. The writ petitioners approached the concerned district land and land reforms officer within bracket DL and LRO for correction of records of rights in terms of a civil court's decree. Which of next para, the DL and LRO referred the matter to the concerned block land and land reforms officer within bracket BL and LRO. Full stop. The matter having been kept pending before the BL and LRO, comma, the petitioners approached the Land Reforms and Tenancy, West Bengal Land Reforms and Tenancy Tribunal for a direction of early disposal of the matter before the BL and LRO. Full stop. However, comma, the said original application has been postponed by the tribunal by its order dated September 23, 2025 to August 11, 2026 comma, which is about 1 year thereafter. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we are of the opinion that instead of relegating the petitioners to the tribunal, comma, OA 2458 of 2025 within bracket LRTT pending before the fourth bench of the West Bengal Land and Reforms and Tenancy Tribunal is hereby disposed of. Full stop. WP LRT 192 of 2025 is also disposed of by directing the concerned BL and LRO, that is respondent number 4. Respondent number 4 to dispose of the matter pending before it as indicated above as expeditiously as possible, comma, positively within 3 months from the date of communication of this order to the respondent number 4. Full stop. For such purpose, comma, the respondent number 4 shall act on a server copy of this order without insisting upon prior production of a certified copy. No rest to cost. Affidavit service filed to be. Thank you, sir. Thank you, Mr. Ghosh. Yes. Next. Yes.
My lord, I beg to represent for the petitioner, my lord. My lord, yesterday, my lord.
You have put in the money?
We have put in the money, my lord.
Yes.
This is the, my lord, receipt.
What is this? Those
receipt of that money and, my lord.
And the previous round of WPLRT, which was not annexed in the writ petition.
My lord, we are also filing a list of dates, my lord. A copy has been served upon the other side.
What are the differences?
No, I think almost, my lord, the same thing. It's a
adjournment for a month. You just ascertain the difference. What nonsense! We are both of you are filing two lists. We could have.
No, my lord. Yesterday I took the responsibility. That's why I'm.
No. Any of the parties.
Oh, that's why we created the problem. Then we'll have to look into both. Very well. Yes.
Anyone will.
First, we look into yours. If there's any difference, Mr. Dhari, you just point out and just point out. Yes. Yes, Mr. Galib.
And these are the documents we have served upon. The same thing. WPLRT one copy is there. Orders and this. They have already same thing, Miller, same set. Miller.
What is the matter?
They want lordship.
What is the matter?
Milord, matter is, Milord, here, Milord, two orders are under challenge. Yesterday, I have already said, Lordship. One is, Milord, the judgment passed in the original application. They were directing, Milord, the concerned authority to correct the record of rights. Milord, from that particular judgment in the original appeal, Milord, a review was preferred. Review was also, Milord, rejected. And on
both are appearing under item 6 or 6 and 7.
No, in one matter, both those,
yes,
that's why Lordship was pleased to, Milord, compensate, Milord.
Review also rejected.
Review rejected on the self-same day, review rejected. At the same time, contempt was there. Contempt also allowed on contest. A date fixed, directed the BLRO, you come with the.
So we'll take up the main challenge. That will
main challenge. If your Lordship is not with the main challenge, then the content part can be taken care of, because direction is you come with the corrected record without any rule.
Right.
My lord, in my humble understanding of this particular entire factual scenario, my lord, there are three issues I find, sides of the matter. Lordship may kindly take up, my lord, my list of dates. My lord, firstly, may I just tell verbally first, my lord? There's vesting takes place with effect from 15th April 2015 under Chapter 2 of State Acquisition Act.
Yes.
Intermediary does not exercise any Form B option. 57 in the year 1957, the intermediary sold 8.18 acres of land by dint of 3 registered sale deeds to the father of the present petitioners. Here responded in this particular. My lord, BR proceeding takes place in the year 1969. being BR proceeding number 548/Roman 3 of 1969.
Yes.
2001, this Narayan Chandra Bhumik, there's a father of the writ petition, original applicant's respondents hearing, comes up with an application for correction of record of rights, saying that I have purchased a portion of this land, kindly correct the record of rights. 2000 not done, so 2001 comes the first original application before the learned tribunal. The first original application is OA number 1590 of 2001, disposed on 16th August 2001. Order Lordship will get at page 78 of my application.
What was that?
What was the order? You consider the representation by passing a resent order. That representation for correction of record of rights. Not done. Contempt follows. Misapplication. Finally, my lord, in the contempt, my lord, there was a direction that you comply with it. Proceeding initiated during the carriage of the contempt proceeding. That proceeding was number 54 of 2001.
Where is the contempt?
No, contempt is MA.
Oh,
MA of 242 of 2002. 242 of 2002 arising out of OA number 15.
No, proceeding number 54 of 2001 is by the BLLO.
54 of 2 by the BLRO that he has started compliance.
All right, then.
He started compliance of that order.
Then why did he stop?
No, he complied. He passes, rejected the prayer. No correction can be done. Now, my lord, that, my lord, Lordship will come. Contempt was dropped. That your Lordship will find. While dropping the contempt, learned tribunal passes the direction that he has rejected, BLR has rejected your prayer for correction. Better, I am giving you a liberty to go for a reference proceeding before the SD LRO under section 57B(3) of the Estate Acquisition Act.
Estate acquisition. এখানে আছে।
Lordship. The, my lord, that order is dated 9th January 2004. Liberty part. Contempt disposed 9th January. Now, Lordship, pursuant to that liberty, SDLRO starts his 57B(3) proceeding.
No, your list of dates says otherwise. Your list of dates says
2003.
Interim order was passed in the same date, 10th of
It
September
appears
2003.
Yes, 10 September, Lordship gets one date, 10 September.
Yes, tribunal in the same date directed.
Another interim order, yes.
Comply with the interim order without being mentioned that proceeding had already been set aside.
Yes, Lordship will get this order at page 81.
So that order was never challenged by you.
26th March 2003, there was an order. In the content proceeding, Lordship gets one date. In that order, it appears said proceeding 54 was set aside, not the BR proceeding, because there was a direction to examine the BR case. This is an interim order passed in the contempt.
Yes, that BR case was directly proceeded with.
Proceeded with.
Subsequently, 10th September.
And 50,
In the meantime, it has been dismissed, but 10th September order does not take note of that.
Yes.
In the same breath, tribunal directed to comply with the order dated 26th of March 2003.
Your Lordship.
That is the first order.
Yes.
That is to continue.
So when this 54 of 2001 was set aside and contempt was pending, another chance was given by the learned tribunal to the BLR to rehear the matter. That is by order dated 10 September 2003.
Rehear.
On another interim order dated 10 September 2003, passed in MA number so and so.
It was reheard. Reheard and rejected.
Reheard. So reheard miss case number is 25 of 2003.
So first, at the first instance, on threat of contempt, this BR proceeding was started.
Lordship?
No, not that. Section 57B was started. This was section 67B.
No. That is
this was the original.
Yes.
On the original direction, this BR proceeding was started. BR proceedings.
No, BR proceeding 1969 already. Correction proceeding.
Sorry, correction proceeding, and that was set aside. Again reheard and again rejected.
Again rejected. Rejection was.
Now this MA was disposed of with this direction, as you said, 57B reference.
Yes.
Since factually incorrect, my lord, may I interrupt? That's why.
On facts, you don't give the correct picture. What can
that is the why, my lord, I had to interject.
You cannot compare the list of dates.
Lord, kindly go to the original order that is at page 44.
So we won't be wasting time here. You will be saying whenever he says some fact will be stated. If you can't concur on facts, you are not entitled to a hearing before a high court. Sorry. You concur on facts. If you please thrash out your facts and then come prepared.
Mechanically, we are on this.
What fact is not there?
The tribunal's order says, moreover, he has mechanically held that since the land vested under the BR case number such and such 548 Roman 3 of 69, the prayer of the applicant cannot be entertained. The learned lawyer for the applicant emphatically submitted. We set aside all the orders passed in the said proceeding, directing the BLLRO Namkhana to hear the applicants within 15 days of this, from the date of communication of this order.
What wrong have I said?
Papers.
So what was suppressed by him? Which fact was stated in
kindly come to the next. Examine the BR proceedings.
Next what? His list of dates.
Yes. Examine the BR proceedings again.
The BLL.
BR proceedings. Tribunal directed the BLL. All orders have been set aside by the tribunal. And
directed 57B.
Yes. No. That stage, during that stage, there was no 57B.
My lord, his contention is that tribunal directed the BLLRO that BR proceeding is washed out totally. He means to say BR case is no more there by dint of this order. As because learned tribunal has set aside. My lord, along with juxtapose showing this date, I shall show the orders also.
So BR proceedings were initiated twice. Initially not proceeded. Not
twice, my lord, only once. My lord, kindly.
Reheard, you said reheard?
Reheard, that is.
The correction.
Yes, 25th March by miscase.
Correction proceedings was one set aside.
One set aside, that was 54 of 2001.
Again, it was reheard in terms of the contempt court's order.
Lord, yes.
Reheard and again rejected.
Yes, that is miscase number 25 of 2003.
After that, contempt was disposed of. Whereby a direction was given, liberty was given to them.
Lordship.
To take out a reference under section 57B.
Lordship.
Took out that reference.
Lordship.
Then what happened? Quickly proceed after that.
So, Lordship, that particular liberty was given.
Yes, don't be so slow. Just the points. Just the important point. 57B3 was taken out, and what happened to that?
So, my lord, 57B4 proceeding was carried out.
B3.
B3, my lord. And so, my lord, in this B3, this authority he has, although liberty was.
That was the SDLRO, which is
SDLRO. 57B3.
What did
he started 57B3 read with 6(1) and 6 subsection 1 and 5 of West Bengal State Act. He has reopened the entire case.
You say he could not do that?
He could not do it. That will appear from page 115, his proceeding, 57B3 proceeding.
So then what?
So that is my first defense on the respectful submission is that
615 was reopened and an order passed in their favor. Ultimately.
In their favor means what he did, he allowed the deceased intermediary to retain the land, including the purchase portion of my learned friend's
He retrospectively allowed the retention. Although there
Yes.
was no BR form, the B form at that point of time.
Yes.
Very well. And
So,
then corrected the records.
B form they are unsigned. Nonetheless, we allowed retention. Kindly see it will appear from our date, from our Milord list of date, first page Milord. Kindly see there is a.
If you allowed retention, then where is the difficulty? Why was
that portion was not?
The other portion which was not permitted to retain?
Purchase per portion was never the retained land of the was not allowed, Milord. That is 1969. Kindly see.
He filed a B form, Form B.
Unsigned B form.
Unsigned Form B to retain that portion also, the sold portion also.
No, that was not there. What for the first time in the 57B3 proceeding, SDLO does that.
No, in the retention form, Form B
Of
also
intermediary, it was not there.
This purchased land was not there.
It was not there.
So he did not even intend to retain that.
No. For the first time, specifically categorically, 57B3 proceeding, SDLRO says
57B3, let us come to section.
Lordship, may I kindly see, Milord. What is 57B3? Milord, 57B, Milord. First, may I respectfully invite your Lordship, subsection 2. No civil court shall entertain any suit or application concerning so and so. ABC. Now 3. 3 say any dispute referred to in clause B may be decided by a revenue officer not below the rank of assistant settlement officer, specially empowered by the state governor in this behalf, who shall dispose of the same in such manner as may be prescribed. So clause B, what is clause B, Milord? A dispute involving determination of the question, either expressly or by implication, whether a riot or intermediary is or is not entitled to retain. So Milord, intermediate riot is the question. Subspecific purchaser is not the question to be dealt with.
Proviso is also
And
there.
proviso is clear that in deciding a dispute under so and so, revenue officer shall not reopen any matter which has already been inquired into, investigated, determined or decided by the state or any authority so and so. So section 4 notification I have showed your Lordship. His vesting was there. So he has reopened the case. So my first full submission is that that was without a jurisdiction, hence a nullity void ab initio. Now, Milord, next comes the second way. After this SDL or 57B3 proceeding, second way comes. What was the second way all about? Milord, second way original application comes on, Milord, that is way number 2750. 2750/2005. That was disposed of on 21st
September. SDLRO order, what did you do? Against that order reopening, what did you do?
We did not prefer any appeal. 57.
Don't be so dramatic about it. You did the wrong thing. You did not prefer an appeal, that chapter is closed. So how can it reopen now?
But without nullity, challenge, no challenge.
What
Lordship, challenge, no challenge.
We did not prefer any appeal. Did not
No,
prefer
that
any
is,
appeal.
they should
Keep
have.
shut and leave the
As
court.
because, no, yes, in the
That attained finally.
DLRO in the order, he has specific statement. Lordship,
doesn't it have to be challenged?
Without, yes, should have been. But even without challenge, nullity is a nullity, Lordship.
Then
We
why
have
are
done
you
from your
preferring this?
Lordship.
If it's a nullity, ignore it. Do whatever you like. If it's a nullity, you need not approach a court of law.
Lordship settled proposition, my lord. Even no challenge.
Nullity, ignore that. Why have you approached the court?
No, thereafter, something happened. Something
else also happened. Yes.
So, my lord, now after this comes the second way. Second way is of 2750/2005, disposed on 21st September 2005.
Forget those dates. You are distracting us. Dispose of on this date. What? Say the crux of the matter. What happened in the
So,
second
since
way?
there are as many as 5.
No, we forget the dates, obviously.
So, my lord,
Second
way was
what happened there.
Lord,
say that.
Second way is issues that there was a status quo order in the first way, that you should not change the nature and character.
The first way was regarding what?
Regarding correction of record of rights.
The contempt was
correction of record of rights.
So that way was still pending when this reference happened.
No, contempt we complied with
along with the contempt, the main way was also, previous way was also disposed of.
Before way was disposed of. Thereafter contempt.
That's very well. So in
contempt we complied with.
In the second way, you challenge what?
They come with the second way.
Against what?
My lord, that is also, I don't get the order. Strictly, that was, my lord, for the same prayer might be. But here, my lord, there was a yes. In the second.
He knows. Let us hear him. Yes.
Second way.
Let us hear him on the facts. Mr. Gali, we are not prepared on the facts.
The second way, my lord, Lordship, I'm ready.
Can't even say what the second way was.
Second way, my lord.
Maybe, might be. What are these?
After second way, my lord, yes, there was a patta.
given by the Milord, the authority, in violation of an order passed in 2001 way, that is first way. So Milord, second way come up. Then second way.
Repeat that, whatever you said, Raf.
Took care of that.
Please repeat that, whatever you said.
Milord, in
Second way was?
in the first way, there was a order of status quo that you were not to change the nature and character. Not
First way you say was disposed of. Before the contempt.
Yes, but despite the status quo order was there. So nonetheless, during that period, subsistence of the status quo order,
yes,
this BLRO, they gave patta. So Milord, patta issue came up. So second,
a patta to third party.
Yes, patta, because vested land taken for granted to a third party given. So in violation of that, so second way comes, second way takes care of that. So second way
takes care of means be clear.
It has to be annulled. You have violated it. So
second way is allowed.
Annulment was done.
Good.
Now third way, third, fourth, and fifth are interrelated.
There are 3 more ways.
Yeah, third, if your lordship comes to third, it will take care of fourth and fifth.
Do that.
Third way, Milord. Third way is, Milord, 762 of 2014. No, that is the mother way, parent way. This order lordship kindly goes through. That is at page 131.
Tell us what, then we'll look through the orders.
Third way is for correction of record of rights. Again.
By whom? Them.
Them. Always are by them.
Why again correction? You did not correct the first time.
It was not done. 57B3 order done, ended. 131 said you corrected appropriate action for a correction of record of rights in accordance with law. This was the language. In accordance with law. Miller not done. Then comes fourth way. He wants implementation of that order of
Not
fourth
done
way.
Fifth. Not done fifth. Not done sixth. Now call your
No, lordship.
We
Done.
want to see your BLA letter.
No, lordship.
Please call him on Monday.
No, lordship.
We want to meet him.
It has been complied with lordship thereafter.
Fifth time not
But
no
it has been
compliance. Sixth
complied
time he
with.
goes to jail. Sorry.
He doesn't complied with lordship. Kindly bear with it. It has been complied with thereafter.
So why are you before us?
And it was disposed of. My learned friend was not happy. Then came before the Honorable High Court.
Disposed of in what way?
You should kindly see.
Why were they unhappy?
Milord, lordship.
Why were they unhappy? What happened?
Because he says, Milord.
Disposed of means exactly what was the order?
Compliance was done, rejection given.
Rejection?
Again
compliance.
Sixth rejection. Post-vesting purchaser, Milord, he is asking for mere correction. We have shown.
After the third way, could you do that?
Milord, they kindly seize the order. He is asking for implementation. Kindly seize the order.
Implementation of what?
That order which they are asking for still now, that it is a mandatory order, peremptory order. You don't have any other way other than to correct it. Kindly, if your lordship says yes.
57, 1 second. 57B3 and 615 reopening was done by the SDLRO, right? So SDLRO directed their name to be recorded after.
No, not recording.
What was
retention
that?
part? Kindly this order.
Retention was done. Retention was directed.
Yes.
Very well. Only retention was directed.
Lordship.
It was held that he was entitled to retain that portion.
That purchase part will be retained by him.
Retained. And no correction of record of right in terms of
there is no direction.
That order has attained finality, SDLR order, retention.
No, but our challenge was there.
You have not challenged, you said.
Challenge, in the review we have taken that.
Mentally you had challenged,
no,
but
in the review
physically you did not.
Lordship, kindly.
So therefore there was no challenge that has attained finality.
57B4 was not there. We did not challenge under
57B4 was not there, right? If that be so, that order is still there. You say it's a nullity, that's a different, we'll hear that argument. But that order, physically, it's there on record. Now, was there any option before you to say that it's a nullity and without challenging it and not implementing it by the correction?
Because the crux is when he is a post-vesting purchaser.
That post-vesting purchaser, that concept, I mean, that goes once the retention is reopened. Even if he's a post, there is no scope of vesting. If the 57B3 order says that he was entitled to retain, by necessary implication, that portion was never vested. Then where comes the question of post-vesting purchase?
If your lordship's Milord is on that yes, your 57B3 has conclusively come to a finding.
Let us make it very clear to Mr. Galip. After the section 57B3 order, and it's a nullity or not, that's a separate chapter. B3 order is there on paper. By virtue of that B3 order, 615 reopening was there, and their vendor was permitted to retain their purchased portion.
Sure.
If that retention happens, if it is not a nullity, let us proceed first on that premise, then that retention automatically takes it out of the pale of the vesting, and therefore they are not post-vesting purchaser, you could not reject.
Nullity apart, certainly, my lord.
Only case is that 57B3 is a nullity. Otherwise, your other action goes.
Lordship.
Now, by the last order, they again approached for correction. BLRO refused, rejected. Rejected on what ground? That order was a nullity that was spelled out.
May I?
That was spelled out.
Yes, Lord.
Against that, they moved an appeal.
A very mere lengthy order, Lordship.
We'll look into that. They challenged it before the appellate authority.
That was not challenged.
So, you did not challenge before the appellate.
In a contempt proceedings of the last fifth OA, they came up before the tribunal and filed a compliance showing that that was a nullity. So we are not going to comply with the court's order. That compliance report, on the basis of compliance report, the LRTT has disposed of the application, my way application. Being aggrieved with that order, we came before this High Court in a previous writ petition, and High Court has considered all these arguments was advanced. High Court has considered, and High Court said, sorry, you can't now raise all these aspects because you have accepted the order.
Then directed what?
And directed the LRTT to revisit and pass the necessary order. On that basis, the Honorable Division Bench has.
Will come to this. Yes, Mr. Gali, please this order also, because you cannot suppress that.
Which one order, my lord? High Court's order.
Ask Mr. Chakravarti, he'll tell you.
No, Lordship. Firstly, that has not been annexed.
WPLRT. Yes, we have shown that. Lordship, kindly cease, Lordship. Kindly cease, Lordship.
Give us the High Court order, Mr. Dhar.
Yes, well, that is.
It is in our bunch also, Lordship.
Even in my
not even understanding which order we are asking for.
Even in my bunch, I have.
Kindly see last order, 3rd October
2023.
Your bunch and his bunch does not have separate characters. I mean, we don't.
My bunch starts with the section 4 notification mode, Lordship. That is the identity.
This is whose bunch?
My bunch.
We'll look into his bunch.
Oh, I should not be believed in, Lordship.
Looks better. Yes. Which page of your bunch?
Just after list of dates. WPLRT 104 of 2023. There was a specific direction.
Let us see that direction. But is the order passed
16 June, 16 June, my lord. Kindly see 131
762 of 2014?
16 June 2014.
Which page?
131 of my petition, Lordship.
Which page of your bunch?
In the petition 131, Lordship.
In WPLRT, in that bundle, my lord.
131 of my petition, Lordship. I am not I'm not playing hide and seek with the Honorable Court. Kindly believe me, Lordship.
Only hide.
I am hiding, Lordship.
We are playing. You are playing hide, you are playing seek. That is 131.
131, my lord. This is the order. My lord, kindly sees, my lord, learned counsel part all over. Having heard both sides and after perusal of the fact on record, we pass the following order. BL and LRO Namkhana Swans was directed to take appropriate action for correction of LR record of rights in favor of the applicants on the basis of Annexure C to the application within a period of 3 months from the date of communication of this order, after giving opportunity hearing to the applicants and other interested persons and passing a reasoned order in accordance with law. But if your lordship is on this, that it is a mandatory order, that you will have to correct it, then I am out of court. But if your lordship says, my lord, that no, it is not a mandatory order, that you will have to, there is no other way but to correct, then I am out of court. But if your lordship is with me, no, you may correct, may not correct the meaning of this, my lord, then, my lord, I have some case, my lord, to be placed before your lordship. In accordance with law, my lord, may I respectfully, my lord, one. In accordance with law, my lord, our.
So, Justice Bossak's division which directed.
This is the only crux, my lord.
This order, implementation of this order to be considered.
Was not done, hence your contempt dropped, wrongly done.
So now let us see the impugned order.
Present. Impugned order, lordship. Impugned order, my lord. My lord, may I rely upon, my lord, the last certified copy after page, my lord, 154, my lord.
Yes.
This is 28th June, my lord, 2024, my lord. And kindly seize the ordering portion. My lord, internal page 8, my lord.
Mr. Galip, please from page 6. We'll get in a nutshell what is the perspective of the tribunal.
The first way 1592 got into gear when the representations submitted with the applicants were turned down by the Trust Authority. The representation was submitted in the year 2001. In that way, BLO Namkhana was directed to consider representation V-Day 16th August 2001. In compliance with the said order, BLO drew up proceedings 54 of 2001, rejected the claim of applicants on the ground that they are post-closing purchasers. Being agreed, applicants filed an MA 242 of 2002 before this tribunal. As per direction of this time, matter was reheard by the BLRO through a Miss Case 25/2003 and again rejected the claim. In disposing of MA 242 by the Honorable Tribunal, liberty was granted to the applicants to make a reference before SDLRO under section 57B3. In compliance, SDLRO initiated a proceeding being number 10, 57B3, coupled with 61 and 65, and this was the same on 18th October 2004, wherein the intermediate was allowed to retain 25 acres of agricultural land, including the purchased land of applicant, 2.50 acres of non-agricultural, 1.13 acres homestead, and vest 11.55 acres. The applicants filed an application before BLRO on the strength of the order to correct the so-and-so. Under complete bewilderment, the applicants again filed OS 2750 in which the BLRO Namkhana was directed to dispose of after giving fair and reasonable opportunity hearing, but no effect. Due to inaction on the part of BLRO, the applicant filed a contempt. MA 516. After wasting much time, BLO Namkhana had to initiate a proceeding 49-2 and send it to SDO, being compelled by the order of this.
So this was the previous order. This was the previous order of the tribunal. There is a further order subsequently we find.
This order of
2025, there is a certified copy. This is probably the
this is
previous
certified copy. Same order, certified copy you have annexed.
Both are certified copies. This is an order dated.
Oh, MA is the last part. That is contempt. Contempt come review.
You are challenging which one? This
I'm challenging you way past 28th June, as well as that MA review and contempt. The second part of the challenge, if your lordship will not be with me.
So let us continue with this. Yes. The discussion is
getting no justice from the end. I'm reading, my lord, last paragraph, internal page 6, my lord. Getting no justice from the end of the quasi-judicial authority, the applicants filed another way, 762/2014, in which Honorable Tribunal directed the BLRO Namkhana to correct LRO in favor of applicant, but it was also uncared for by the BLLRO. Finding no alternative, the applicants again filed OA 645/2017.
Mr. Galip, this order was passed after Justice Bossak's order.
Yes. After Justice Bossak's order. And hence, my lord, mandatory direction, my lord, in internal page 8, third paragraph, the BLNRO Namkhana is directed to correct the LRROR with respect to the subject property and record the names of applicants accordingly within a period of 2 months from date of communication without fail. DLLRO being appropriate authority direct to ensure this and that. So this is
there were two components to prayer B, which was directed by Justice Bossak's bench to be heard. Prayer B says an order directing the respondent of 5 to implement the order passed by the Honorable Tribunal, which is what you were saying, the Tribunal
762 of 2014.
Yes, and mutate the name of the applicant of the suit plots mentioned in paragraph number such and such. So there were two components. Both components were decided, and the tribunal said mutate the names. Therefore, both components were decided by the tribunal. There was that aspect also. to mutate the name was also part of the prayer which was directed by Justice Bosak to be considered by the tribunal. Now, therefore, this direction was not beyond the direction of the High Court. Even if we presume or proceed on the premise, on your premise, which has a point, you have a point there, further direction for consideration and this in accordance with law keeps it somewhat open. You are right.
In respect to reply to the query of the Honorable Court, my lord, may I
Justice
place the
Bosak's
order,
court or
Justice
our
Bosak's order? Kindly,
query of us now this.
my lord, kindly, Justice Bosak's order, my lord.
You are answering Justice Bosak or us?
My lord, I am answerable to your lordship
Yes,
now,
yes.
my lord, in this proceeding, my lord. My lord, kindly seize, my lord, the prayer clause my learned Honorable Coordinator Bench has quoted.
Yes, we are reading from that only and muted the name
Now
of
kindly seize, no, the prayer clause is quoted in extenso. Now prayer B of the original application is yet to be considered.
prayer B is what we read to you.
And mutate the name.
Yes.
Of the suit plots mentioned so and so. I mean, OA and will kindly sees. It is right law that the tribunal cannot abdicate its jurisdiction in deciding the issue raised in the original.
Division is directed B to be considered. B contains mutation prayer also.
But Miller 16th June order was the order of disposal of OA 762. 16th June order was the order. That is the order of disposal.
We are reading it for you. Justice Bosak's division bench, final part. Prayer B of the original application is yet to be considered and decided by the tribunal. It is trite law that the tribunal cannot abdicate its jurisdiction in deciding issues raised in the original application and remit the original application for decision to the appropriate authorities. In the facts, subsists an earlier order passed by the tribunal in an earlier original application being such and such, requiring concerned BLRO to act in a particular way. Writ petitioners approached tribunal for relief with regard to such order. Tribunal was vested with jurisdiction to consider as to whether order was carried out or not. Refused in such circumstances, set aside the impugned order and remand the OA for hearing and decision by the tribunal on merits. So the entire OA was remanded to the tribunal to be heard on merits. And it was said, since the original proceeding is pending, within a limited period. Now, therefore, not only B or A, but the entire OA was sent back to the tribunal.
Yes, but
The tribunal now looks into the entire order. Entire order means entire original application hard approach means A, B, C, D all come. A is an order directing respondent number 5 to dispose of the mutation applications. B is of two parts. One is implementation of previous OA and mutate the name of the applicant of the suit plots mentioned in such and such. So therefore, they also ask for mutation. Tribunal, by this order which you are now placing the certified copy, tribunal took into consideration both. We are proceeding on your premise. You have a point there. We are saying that yes, previous OA direction kept it somewhat open by saying that in accordance with law and giving opportunity of hearing all these things, not direct direction to mute it. But the other prayer is also there. The prayer to mutate the names is also there in their OA, which is directed to be reheard by the tribunal, by previous division bench. Now that is done. And it is said that BLR Namkar is directed to correct the error ROR with respect to the subject property and to record the names. While doing so, the tribunal also considers at internal page 6 of the certified copy which you are placing before us, that SDLRO has already undertaken an exercise under 57B3 coupled with 615, wherein intermediary was allowed to retain 25 acres of agricultural land. The applicants filed an application such and such. Therefore, tribunal takes into consideration the 57B3 including 615 1 and 5 order and says that BLRO is to mutate their names because of this order, by which intermediary who was their vendor, he was allowed to retain that land. If he was allowed to retain, you cannot reject them, their mutation prayer, by saying that they're post-vesting transferees.
Plea of nullity apart.
Achha, why do you say it's a nullity? Now satisfy on only question is nullity, because the rest follows. BLLR tribunal was within its jurisdiction to consider the entire OA and direct mutation on the basis of the SDLR order. It was within jurisdiction. And subsequently to issue a contempt rule also, unless you satisfy us that it's nullity in the eye of law. Why do you say it's a legal error at best? At best, it was a legal error. Why do you say it's a nullity?
Lordship, I am on that, Lordship. This OA 762 of 2014.
Yes.
OA 762 of 2014 was disposed on, my lord, 16 June 2014.
Why do you stop? Please continue.
Well, that particular disposal was in accordance with law, I have already shown your lordship.
Why is it a nullity? We are asking you that.
Nullity, lordship. Well, 57B2 says, my lord, 57B says, my lord, clause B of subsection 2 is to be taken into
Shall
consideration.
not reopen. Shall not reopen. Provided.
Shall not reopen. And, my lord, so he has reopened it. So, my lord, since the government has already by notification vested under section, by conjoint operation of section 4 and 5, he cannot reopen that particular issue. That is first. Second, without jurisdiction is that, my lord, the right of retention, the question is with regard to Rayat or intermediary. It is not, my lord, as unable to a post-vesting transferee, which has been given over here by the, my lord, SDLR.
You are again coming back to post-vesting. Post-vesting concept goes if that SDLR order
As
remains.
because, my lord, reopen, lordship.
Was the SDLR order?
Lordship. My lord, 115, my lord, of my petition, lordship. Page 115, my lord, that is order number 1. But the final order is at page, my lord, 117. 117, this is, my lord, it's not eligible. It's eligible. 18th October 2004 is the final order. Kindly seize, my lord, the relevant part.
Pashupati Bhomik was the predecessor.
Lordship.
Pashupati Bhomik was the predecessor.
Applicant Sri
was
Pashupati.
Pashupati.
Lordship. My lord, may I read out the relevant, lordship?
Yes.
Relevant part, my lord, 118. Second paragraph.
So Gopal Chandra Hait was the intermediary.
Was the intermediary. So what does he say, my lord?
Sorry. And Pashupati Bhomik was the...
Your father. You are Narayan.
Yes, I am Narayan.
Pashupati was your father.
No, legal heirs of the previous intermediaries.
Sri Narayan Bhomik is appearing on behalf of applicants. That is Sri Pashupati Bhomik.
All right. Achha, your father purchased the property.
Yes.
And Gopal Chandra Hait was the intermediary.
Intermediary.
Very.
So, my lord, kindly see the concluding part, my lord. What he says, my lord. At page 118, my lord. The sentence start in the proceeding 25 of 2003, learned BLO did not allow him intermediary to retain as per provision of the said section. Deceased intermediary held 11.13 agree land 0.5 swans, who is giving the description. Now, my lord, what does he say towards the end? On the date, my lord, on the date of vesting, but he did not submit any B form as stated. Learned BLO, it appears in BR proceeding of 1969 that heirs of deceased intermediary submitted B option statement on 16/6/69, which was not, you know, this what whether
not signed
by the heir of the deceased, Gopal Chandra Hait. So it is not a fact that Gopal Chandra Hait or his heirs did not submit B option statement. Deceased Gopal Hait had transferred 2.53 acre of land, Moja so and so during mischief period, that is 55, 53 to date of vesting. This land has been included in the above total land description. Sri Narayan Chandra Bhomik stated that their purchased land was mutated and government accepted rent from their land should not be vested. It appears Sri Pachu Molla versus so where the state has mutated the name of post-vesting transferee, and as such transfer has
and then accepted rent from
rent. Such transferee has accepted a tenancy right.
Acquired.
Sorry, Miller. Acquired a tenancy right under the state. With the, therefore, cannot vest in the state. Sri Bhumik, thereafter they distributed the patta during proceeding of LRTT, being number so and so. In this case, he submitted a Xerox copy of the patta being RS case number so and so, serial number so and so, in view, which is deserves to be cancelled. In view of above facts, deceased Gopal Haith is entitled to retain so much of land as per provision laid down under section 61 CD of West Bengal State Acquisition Act, and transferred land should be put in the retained schedule of the intermediary. Schedule of land held by the intermediary on the date of vesting given as follows. So this was the retained part. It has been directly, just last page, it has been already mentioned that late Gopal Haith had a transfer 2.53 acre land of Moja so and so. That was declared bona fide transfer in 5A proceeding being 3 of 69. This land will be included in the retained schedule of the intermediary. In view of the above facts, it is ordered that deceased intermediary is allowed to retain 25 so and so, including purchased land by the petitioner's father, that is so and so, and 11 having Moja so and so shown in Schedule D shall be vested in the state. This order is not prevent to.
Why didn't you challenge this order, Mr. Valley? You should have challenged this order. This is a bad order, maybe in law, subject to hearing, Mr. Dhar. But how can you say it's a nullity? How can you avoid it altogether? It was passed under section 57B. Proviso says you cannot reopen while doing so.
Lordship.
But jurisdiction lay in him because there was a reference by the tribunal, which
only
also
for 57B3 kindly take note.
57B3. 57B3 is any dispute referred to which relates to whether Rayat is an intermediary entitled to retain. So therefore, he had jurisdiction on that day when the tribunal directed him to exercise his power under section 57B3. 3 read with 2B. He had the power. What he did not have was the power to reopen previous issues. So he was not acting without jurisdiction in exercising 2B power. It was not a jurisdictional error of such a magnitude that he did not have any jurisdiction. Suppose some other authority had the jurisdiction to decide 57B. Then we could have understood. He had jurisdiction under 57B3 to decide any dispute referred to in 2B, which he was doing. So he was within jurisdiction but acted illegally by not taking into consideration the proviso. But then you had to challenge it. It does not become a nullity for lack of jurisdiction. He had jurisdiction to take up 57B3 adjudication.
This 2B, Milord says, of Rayat and intermediary.
Yes.
Retention part is to be decided by him.
Yes. Whether a Rayat or an intermediary. He has decided regarding intermediary retention. He had that power under 3.
Of the deceased intermediary unsigned, Milord part.
Unsigned is on fact. Proviso is on law. But he had jurisdiction to decide under section 57B3 what? Any dispute covered by 2B. What is that? Any dispute of an intermediary, his entitlement to retain under the provisions of that. So he did just that. He decided the right of the intermediary to retain a land. So he was acting in jurisdiction, within jurisdiction, Mr. Gali. So it's not a nullity. It's a legal error, which was unable to challenge. You did not challenge.
Kindly appreciate me, Lord.
57B4 was there. You did not avail of that. It has that in finality. No. Not a nullity.
No, Lordship, nullity, Milord, as because he was, Milord, allowing the applicants, Milord, to retain the land.
It's a legal error, not a nullity.
But it is beyond the scope of, Milord, clause B, 2B.
He said that the intermediary was entitled to retain because he had filed before, which was not considered.
This is the intermediary, Milord.
Yes, Mr. Dhar, what do you have to say? Any judgment you want to cite? Nullity or anything?
No, nullity, Milord, we have that. And Milord, self-same case, what my learned friend is also taking a point, and in the writ also he has taken a point, that we have been paying dakhila. Now in the writ,
Machumolla's case has been referred.
Lordship.
Pachumolla has been referred.
Yes, no, my learned friend has taken also a point that we have been paying.
Pachumolla wasn't that. You read
Yes,
the SDLR rules.
but
That
I
was
shall show you, Lordship, Belthoria is very much clear on this. Milord, he has shown, now, firstly, we kindly see the fact. Milord, the writ petition which my learned friend has handed, I have also handed over. Kindly see, he has shown one Dakila, which is of 1954, without any dag or khatiyan. So a man who is purchasing the land in the year 1957, how can he pay the Milord Dakila in the 1954, Milord?
His name.
Yes, I find.
Marfati Khotian.
Yes, Dijendranath.
আমার নামে নয় ওটা
He's not Dijendranath.
Come on.
So, my case is that a post-vesting purchaser, he has been given my window Miller to reopen the case through Miller 57B2, 57B3.
Understood, but you
which is not Miller permissible. Miller kindly takes Rajawala Barik.
You let that attain finality, Mr. Bari. How can you say it's a nullity? It's a legal error. Definitely, it's a legal error, palpable. Attain finality, what can be done? You did not challenge.
Miller, he has opened 6, 1, and 5.
You may be unhappy about that, but you should have challenged them.
Lordship, I have judgments on post-vesting.
Post-vesting, yes. No, but that post-vesting, that stigma has been taken off by this SDLR order. That is the difficulty here. Post-vesting transferee under Estate Acquisition Act cannot reopen.
So, Miller, my lords are of the opinion that 57B3 exercise, my lord, was very much within jurisdiction, Lordship. If it is Miller, I am out, Lordship.
You are.
I am out.
Bold. Mr. Dhar, answer our
And
questions.
content, Milord, is Lordship, content part is Milord.
We'll look at him or her and decide whether we should send him to jail or that will decide. We have the decision. Yes, Mr. Dhar, answer these questions. Why is it not a nullity? Proviso. Proviso. 57B3 proviso. Why is it not a nullity, as Mr. Galib is arguing? It's a specific bar. So he did not have the jurisdiction to reopen.
What is the 6-1 proceedings? 6-1 proceedings is, as per section 4 and 5, conjoined effect of 4 and 5, the entire land, excluding those who are guided under TICA, those who are guided under Non-Agricultural Tenancy Act, and those who are guided under or coming under 1 to 100 KMC area. Excluding those, every land got vested. So whoever is purchasing after the date of vesting, they are nomenclatured as post-vesting transferee or post-vesting purchaser. But simultaneously, there was a right protected under section 6. That is right to retention. And right to retention starts with the section, starts with the clause word notwithstanding anything, with a non-obstante clause, and section 6 says, yes, the intermediaries and the riots are entitled.
Please come to 6.5.
I'll go to that 6.5.
We know what there is in 1.
If
you are not the intermediary, come on.
Yes.
Intermediary was entitled. Come to 5. Answer 5.5.
If 6.1 does not happen, if intermediary does not go
6.5, place it.
6.5 is the situation if riot or intermediary does not.
Legislative language is better than
an intermediary shall exercise his choice of retention of land under subsection 1 within such time and in such manner as may be prescribed in the rules. It's not here, but rules prescribed. If no choice is exercised by him during the prescribed period, the revenue officer shall, after giving him an opportunity of being heard, allow him to retain so much of the lands as do not exceed the limits specified in clauses C, D, and J on that subsection. It does not mean that intermediary did not come before the authority within the stipulated time period, hence entire land gets vested. No, 6.5 says if he does not come, then authority will invite that intermediary, come before me and do the exercise. If he does not come, then on behalf of intermediary, the authority will do that exercise by retaining whatever the ceiling has been prescribed under the act. Not the entire land gets vested. If he is entitled 25 acres agricultural, if he is entitled 15 acres non-agricultural, if he is entitled 5 acres homestead, then that's his right, which has been protected under section 6. If 6.1 does not happen, then 6.5 comes into play.
এখানে এসডিএল এর বলছে এক্সারসাইজটাই হয় না, যদি এক্সারসাইজ না হয় তাহলে জুরিসডিকশন এর হচ্ছে না, লিগ্যাল এর কিন্তু সেটা সঙ্গে ফ্যাকচুয়াল এর তো হচ্ছে সেটা তো করেনি, এখন সেটা ধরে আমি স্টেটে ফেভারে বেস্ট কেসটাই যদি ধরি তাহলে
Yes, Mr. Acha, is there anything on record to show that this opportunity of hearing was given under 6?
To me?
To my to you, intermediary. You do not come into the picture.
Well, kindly, all these aspects have been dealt with in the previous.
Show us that finding.
Well, kindly come to their compliance report in my previous WPLRT and every aspect.
Where do we find it?
Well, at page.
The month or the writ petition?
In the previous writ petition, well, kindly come to after page 70.
Previous writ petition means?
Means WPLRT 104 of 2023. Well, after my list of dates, well, there is a bunch.
This is what you are asking.
Yes.
Compliance. So Justice Bossak's division?
Yes, yes. Just after that. After the order.
Yes, after the order.
Compliance টা দেখাও, পেজটা বলো। Last 10 pages or so, filed by the BLLRO before the LRTT.
Where do we find that? In your bunch, which page? Which page? Running page?
Running page is not there. After page 78.
78.
Miss case 2 of 2010.
Miss case 2, Miller Lordship will get from our Millard pleadings, Millard. That is starts from page 85 onwards.
This is SDLR order?
No, this is by BLLR.
BLLR.
Kindly seize Millard, page 85 onwards. By taking into consideration 3 orders of 3 OAs, he passes it. That was I was referring to in the course of my argument, Lordship. It's a very lengthy order. 12/5/2023.
Yes.
85 onwards.
Right. Yes, Mr. Thor.
Yes. Well, kindly come to paragraph 6, 7. All these aspects have been submitted, was considered by the Honorable Division Bench.
Have you got a copy of their application? The present writ petition. Show us from there. Page 85, Mr. Galip.
85 onwards.
Present.
You are showing from that only.
Just show us.
No. আমি আগেরটার থেকে দেখাচ্ছি।
85 onwards.
No.
88 onwards.
This is the
2 of 2010.
This is the order sheet. They have filed a compliance report before the LRTT, and LRTT, upon considering that compliance report, on the first instance, LRTT disposed of. Challenging that order disposal, we came before this court by filing WPLRT. And in that proceedings, this compliance report was filed, where they tried to again reopen by saying that that was a nullity, 57B3's order was nullity, everything. They stated everything.
So this 6/6/2023 you are placing.
Yes.
So this was after what Mr. Gali was showing, 26th of May 2023.
Yes. Just after that, my lord,
Yes, sir.
26th May of 2023, my lord has got it.
We have got 6th May. No,
26th
26th May. Yes, Mr. Gali was
Yes.
placed.
My lord,
Now you are placing
paragraph 6-7
of 26th May.
Of 26th May 2023.
Very well. Yes.
কতবার খুলবে বাপরে বাপ হাঁপিয়ে গেছি মানে 6 মানে that being aggrieved such and such that to comply the solemn order in para 7 MA such and such the SDLRO Kakdeep initiated a proceedings under section 57B3 53 read with section 61 65 such and such. All this been dealt with. Then Kiran Singh, all judgments of the Supreme Court was relied.
Let us see that. Yes.
Para 10, Malad, kindly come to para 10. Then Malad, kindly come to all the judgments. Kindly come to the internal page 8, the crux of the orders passed by the Honorable Tribunal in this 8. Malad has got it. Internal page 8.
No, internal page number is here.
Internal page.
In our copy. 92. Yes, those have been crossed. Very late.
8.
The
Then
crux of the orders. Crux of the orders, yes.
Crux of the orders, Malad has got it.
Yes, yes.
Yes. Then Malad, kindly turn to the next page.
This was after the third.
Yes.
Way.
No, this is after the 5th way.
Oh, after the 5th. Yes.
Before Justice Boshak's order. Subsequently, to comply with the order dated 16 June, Malad has got it. Passed by the Honorable Tribunal in OA, the then BLLRO Namkhana initiated a proceeding VD case number 2 of 10 and issued notice for hearing, but no constructed order sheet is stressed in this office now to comply with the order passed by the Honorable Tribunal dated 14th December 2022. That was the last OA. In OA number 1319 of 2022, these proceedings with a case number is reinitiated. Then all Supreme Court judgments, 57B3 also quoted, 6165 also quoted. Then Malad, kindly come to the internal page number 13.
শিটগুলি দেখাচ্ছিল তারপরে 6 জুনে ড্রপ করে দেবে তারপরে এলআরটি
Kiran Singh, Malad has got it. Then Sundar Das, Kalinath, every judgment.
Nullity was argued by them.
Yes, nullity was argued, and the Honorable Division Bench has asked them, Malad, in my presence, ask your BLLRO to appear.
No, so taking the ratio of the law, safely decided.
So taking the ratio of the law as declared by
jurisdiction.
Yes, without jurisdiction. They failed on that
count. Contempt. It's a beautiful adjudication, elaborate adjudication.
Yes.
Like a court of law.
I did not say it was a contempt. No.
BLLR, he has adjudicated very well. We must appreciate this.
Yes. Absolutely.
Held in one way or the other, we may or may not agree with
Absolutely.
But fantastic judgment. I mean,
yes.
The BLLR
so many judgments have been considered and held. No, I am
well written judgment. Actually.
Yes. And this aspect was considered.
This is not a contempt because the contempt.
I'm not saying it's a
second challenge is against contempt. She has been asked to comply and be present.
Yes, because after considering this compliance report, which right now I am relying, the Honorable.
You don't see any compliance report here.
And this is
the next page is 66 order after page 78.
Well, right now taking.
What is the date of that compliance report?
That is.
Yes, after that.
Yes.
2nd of June.
Yes. 26th May 2023. This was the compliance report.
It's not there in your bunch.
It is there on page 16, my lord. So taking the ratio of the law, my lord has got that paragraph. My lord has read that paragraph.
Paragraph of compliance report.
Yes.
26 May is an order.
Hence the representation.
26 May is an order. It's not a compliance report.
This was placed in a formal letter before the LRTT.
So I have shown that only. The order sheet I have shown
The
20.
order itself has been shown by him.
Yes. Then
yes, they say they have complied with by passing this order.
Yes.
Obviously, that is
Malad,
their case.
Yes. Now, Malad,
So where do they admit anything which you are saying? They don't admit anything.
No, I'm not saying.
Proceeded on the premise that
Even considering this compliance report, the previous coordinate bench has sent the matter back before the LRTT for restricted remand. I say that B part is where the previous coordinate bench has
your prayer, just see your prayers. Justice Bosak's division bench quotes those prayers
yes
on which it was remanded.
yes
First prayer is an order directing the respondent to dispose of the mutation applications, not to mutate their names directly or implement any order. Second part is implement the order passed by tribunal in OA number 762 of 2014 and mutate the name of the applicant. Now, you have connected the two, implementation of that order by mutating your name.
Yes.
But that order does not directly direct the BLR to mutate your name. It says that you have to be given a hearing, and in accordance with law, that will be decided.
Yes.
Now that has been done in accordance with law.
That has not that has
Yes, decided in accordance with law. If you are aggrieved by this, you should have preferred an appeal against this GLR order.
This compliance report is the prior to Justice Devanshu Bosak's division bench order.
So what? The compliance is done. They say that we have complied. BLR has passed an order, a reasoned order.
May I?
OA direction was to pass a reasoned order upon giving opportunity of hearing and in accordance with law. BLR has done that. If you are agreed by this, at no point of time it was there. SDLR order was not challenged. We can appreciate that.
Yes.
After the SDLR order, there was no direction at any point of time by the tribunal or anybody to implement the SDLR order.
Yes, there was.
Shows that.
Yes. Well, kindly come to the bunch of my previous WPLRT.
Yeah. You should have paginated at least.
Well, that is paginated.
Give us the page number.
Well, at page 65.
Yes.
This is the higher officials of SDLR on 4th July 2006 saying that before correction of ROR in compliance with the order dated 18th October 2004 of SDLR, referring to SDLR's order passed in miss case number 10 of 2004, initiated under section 57B3, read with section 6.1 and 6.5 of the West Bengal Estate Acquisition Act 1953. In the above noted subject, he is directed to initiate a proceedings under section 49(2) of the WBLR Act 55, read with rule 20B of the West Bengal.
This is before correction of ROR is complied with.
Patta cancellation.
They are to, yes, take steps for patta cancellation. This is different.
This is.
But there is no direction by the tribunal or any or the High Court.
They are after tribunals. I'll take your lordship.
Show us one direction by the tribunal, Mr.
2005.
Show us that where it has been directed that correct the mutate the records. Every time we are seeing the 5 rounds of litigation, every time consider representation in accordance with law and such so and so.
Yes, in favor of my client.
In favor of your client, where was it?
I'll take your lordship.
If it was in favor of your clients, they would have been directed directly to mutate the name, not considered in accordance with law. And
Tribunal this time has looked into that order and
looked into, but every time we find in accordance with law, they will decide on the representation and all.
2005 way.
Show us the page number, get your order.
Page ta bolo.
2005 একটা
প্রত্যেকবার ট্রাইব্যুনাল গেছে ট্রাইব্যুনাল কোর্টে চ্যালেঞ্জ করে
পেজ 66
পক্ষই সমান এরাও এসডিএল এর অর্ডার চ্যালেঞ্জ করছে এটা করলে আমি ঝামেলায় থাকতো
না এটা তো 49
এরা যদি এখন ডিএল এর রিজনাল অর্ডার দেখি তাহলে সেটাকে কানেক্ট করতে ডিএল এর অর্ডার ইন ফেভার অফ কিন্তু কন্টেম্পোরারি অর্ডার
মানে kindly come to page 73. This order has been taken note of by Justice Devanshu Bashar, and that was the.
This was set aside and remanded.
No, this was taken.
Previous one.
Yes, page 73. Malad, in the middle portion, having heard both sides and after perusal of the facts on record, we pass the following order. BLLR Namkhana, District South 24 Parganas, is directed to take appropriate action for correction of LR record of rights in favor of the applicant.
This is Annexure C, SDLR order.
Yes. Malad, then thereafter subsequent all order says comply that order. Always.
In June. We have shown 16 June.
Show us that.
Now,
Any further order?
Yes. 16 June's order.
The 16 June you have shown in accordance with law.
আরে ভাই আমার সাথে তো জজ কথা বলছি
Bill 131 আমাদের আছে তো written.
আমি বলিনি তো তোমার নেই মানে পেজ মানে after page 73 the
But Mr. Dhar, here it says is directed to take appropriate action for correction of LR record in favor of such as on basis of Annexure C within a period of 3 months. What is this after opportunity, giving opportunity of hearing to the applicants and other interested persons and passing a reasoned order in accordance with law?
Yes.
So then they
for
reopen.
mutation hearing, someone has to be present in front of the hearing officer. That has to
Direction would suffice if tribunal directed simplicity or correct the records of rights. Tribunal has
without following the proceeding.
What procedure?
Under 51F. That has to be done. Even High Court directs the authority has to hear the particular person.
Let us see 51.
Yes.
Of land reforms.
Of land reforms. এটা estate acquisition. 51F টা দাও।
সবাই আমাদের আছে।
Even Supreme Court directs that basic procedure has to be fulfilled.
লাস্ট পজিশন দাঁড়ালো এই অর্ডারটা রয়েছে এটা ইমপ্লিমেন্টেশন চাইলে বসাকে জাস্টিস বসা বলুন যে আবার ফেরত পাঠাবো তাতে ট্রাইব্যুনাল কি বলবে আচ্ছা হোয়াট ইজ দি অর্ডার পাস বাই দি ট্রাইব্যুনাল আফটার জাস্টিস বসাক's ডিভিশন বেঞ্চ
This is the order now order impugned before my lord.
That is the order impugned.
That is the order impugned. And tribunal has categorically considered the Justice Bosak's order because the tribunal could not travel beyond Justice Bosak's order. Tribunal's hands were tied. After 2014, if my lord wanted to see the other orders of the tribunal, that is at page 77. Again, same direction, you comply with the order dated 16 June 2014. Again in the year 2017.
Yes, Mr. Galib, in reply.
My only respectful reply to the contention learned senior friend is this, my lord.
Before my learned friend starts, my lord, I'd be relying on few judgments.
On what point?
My lord, on the issue estoppel and constructive res judicata, that this issue was already raised by them in previous occasions, and everywhere tribunal has deprecated this and asked them to consider. Even by the compliance report before the division bench, they could not satisfy the previous coordinate bench.
Show us one subsequent judgment of the tribunal after this 16-6.
14.
14.
Well, page 77.
77. No, 77 is reopens the issue rather.
Yes.
Dispose of the proceeding initiated by heirs in compliance with the order dated 16/6/2014 by passing a reasoned order within a period of 4 months. These
That is-
orders were not challenged by you.
Not
It was reopened, basically.
Again, thereafter.
How do you say issue estoppel?
Well, this was argued by them.
Issue estoppel can be said applied against you also because you did not challenge this order.
Tribunal only said that you please consider the previous order and hear them.
No, page 77, direct BLLRO to dispose of the proceeding initiated by him in compliance with the order dated 16/6/2014. So 16/6/2014 and proceeding was initiated. The tribunal said the proceeding should be disposed of by a reasoned order.
You please complete this.
Only that.
Yes, only that.
So you say
now,
entire thing flows from 16/6.
Absolutely, absolutely. Now, my lord, the other aspect, the ADM's letter I have shown in 2006, my lord said that is only 49.2. That is relating to patta, cancellation of patta, annulment.
That does not have a direct bearing.
I have, subject to correction.
Yes, why?
I have. Why I say this? The vesting happens on intermediaries' land or riots' land. Thereafter, patta is granted. So it's linked, it's dependent on others.
The patta has been cancelled.
Yes, patta has been cancelled. Not only that, ADM has also directed to mutate the name as per the SDLRO's order. One of my learned junior wants to place me only page 66
of bunch
of my that bunch.
Yes. Yes.
So authority cannot reprobate and approbate, simultaneously blow hot and cold. The entire matter relates to drawing up a proceedings under section 49(2) of the West Bengal Land Reforms Act for cancellation of patta. From the letter being number such and such, dated 18 February 2010, issued by the ADM, DLLRO, South 24, it appears that he has been pleased to direct the BLLRO Namkhana to comply with the order of the SDLRO, passed in miss case number 10 of everything goes back to that SDLRO's order. But that has not been complied with as yet. So this is a byproduct of that order. So one cannot say, okay, I'll do this part, I will not do the rest of the part. Then we record it with utter surprise that we are not in the know as to what is preventing the BLLRO concerned to comply with the order of this tribunal and also the order of the ADM DLLRO South 24 Parganas. The submission of both sides and the total materials on record go to constrain us to call the BLLRO concerned with the report of compliance regarding this matter. At least thrice the concerned BLLRO was asked to appear personally.
Justice Bossak's division bench was against page 77.
No.
Subsequent.
After subsequent. All these been considered by Justice Bossak.
Well. Yes, now let us hear Mr. Khalid. If judgments issuable and restituted will need not cite judgments.
Yes. I am deeply obliged.
My lord, a very short reply, my lord.
Yes, Mr.
Before Honorable Coordinate Bench was against the order, that is 6 June 2023, that is at 102, page 102 of my Milord Lordship. What the Honorable Coordinate Bench has quoted a particular prayer clause. That prayer clause, my lord, is the prayer clause of the present OA.
Yes.
That is at page, my lord, 105 of my pleading. Prayer clause is, my lord, at page, my lord, 112. This prayer has been quoted. So, my lord, prayer B has been taken care of. What does it say? To implement an order directing respondent 5 to implement the order passed by the Honorable Tribunal in OA 762 of 2014 and mutate the name of the applicant of the suit plot mentioned in para 6.2 of this. So, my lords, What was the order passed? My only defense. What was the order passed in OA 762? He wanted the implementation of the order passed in OA 762. The order passed in 762 is at page 131. That is 16 June 2014. 16 June 2014, I have shown your Lordship what was the Milord order all about. Lordship has also read time and again, Milord, that you are to decide that in accordance with law. So this is the genesis, that you complied with, tribunal held, yes, you have complied, dropped it. My learned friend comes to Honorable High Court, and High Court says, so Milord, this 16 June is the Milord primary issue which is to be complied with. So 16 June says in accordance with law, Milord. So Milord, in accordance with law, if your Lordship is that mandatory direction, Milord, then we are nowhere, Milord. This is Milord. And content per Lordship kindly takes care of that, Lordship.
The contempt is consequential to what we hold here.
Lordship.
The present writ petition is a composite challenge to two orders of the Land Reforms and Tenancy Tribunal, pushed up. By the first comma, it was held by the learned tribunal that upon the considerations as reflected in the said judgment, comma, it is axiomatic that the BL and LRO, comma, Namkhana, by adopting sophistry, SOPHIS thereby, deliberately violated the order of the tribunal time and again, and for insubordination to the SDL and LRO, comma, Kakdweep, comma, the said BL and LRO is liable to be condemned. Full stop. It was further recorded that the BL and LRO is directed to correct the LR records of rights with respect to the subject property and to record the names of the applicants within bracket present petitioners. Within bracket present private respondents, bracket closed. Accordingly, within a period of 2 months from the date of communication of the order without fail. Full stop. The district land and land reforms officer, comma, South 24 Parganas, comma, being the appropriate authority, AA capital, was directed to ensure that the order is duly complied with by the BL and LRO within the period specified above. Full stop. Next para. By the second impugned order, comma, the contempt application filed by the present private respondents was allowed on contest, comma, thereby along with a review application filed by the state in respect of the first impugned order being rejected, comma, thereby directing that the BL and LRO Namkhana shall, within 15 working days from the date of receipt of the order of the tribunal, comma, correct the records of rights in favor of the applicants with respect to the subject property. Full stop. The state was directed to ensure retention of the BL and LRO Namkhana in post, comma, until full compliance is achieved. Full stop. Next para. Learned senior government advocate argues that the private respondents stroke writ petitioners, the private respondents are post-vesting transferees. Full stop. Next para. It is contended that in due process of law, comma, within the contemplation of section 6 of the West Bengal Estate Acquisition Act 1953, comma, an exercise was undertaken in respect of vesting of the subject plot of land. Full stop. Although the original intermediary Sri Gopal Chandra Haith had apparently filed a form B, comma, for retention of certain lands, comma, it was ultimately discovered that such form was filed by the heirs of the said Gopal Chandra Haith, comma, that too without any signature. Full stop. In such view of the matter, comma, there being no proper form B having been filed for retention, comma, the subject land stood vested in the state. Full stop. learned senior government advocate further submits that the portion of the land, portion of the other land of the said intermediary, comma, which came within the ceiling limit, comma, was permitted to be retained. Full stop, next para. However, comma, despite such exercise having been concluded, comma, the private respondents stroke post hyphen vesting purchasers sought to reopen the issue by relying on a purchase deed executed in favor of their predecessor in interest, allegedly by the intermediary Gopal Chandra Haith. Full it is argued that on the premise of the same, comma, the post-vesting purchasers sought to mutate their names in the records of rights. Full next para. Upon there being alleged inaction of the part of the BL and LRO, comma, the Land Reforms and Tenancy Tribunal was moved, comma, on which the tribunal directed the BL and LRO to consider the representation of the private respondents in accordance with law. Full stop. After several rounds of litigation, comma, the tribunal lastly granted liberty to the private respondents to have a reference before the concerned officer within bracket SDLRO under section 57 capital B within bracket 3 of the 1953 Act. Full stop, next para. However, comma, the SDLRO, comma, going beyond his jurisdiction, comma, reopened the vesting stroke retention process under section 6 of the said Act and came to the conclusion that Gopal Chandra Haith was entitled to retain the land which has been purchased by the post-vesting transferees. Full stop, next para. Learned senior government advocate contends that the said order, comma, being without authority and contrary to the proviso to subsection 3 of section 57 capital B, comma, is a nullity in the eye of law and as such need not have been challenged by the state at all. Full stop, next para. However, comma, subsequently on the premise of the said order of the SD and LRO, comma, the private respondents moved the Land Reforms and Tenancy Tribunal again. Full stop, the tribunal directed the directed the BL and LRO to consider the said to language to take appropriate action for correction of LR record of rights in favor of the applicants on the basis of Annexure C to the original application within a period of 3 months from the date of communication of the order, comma, তারপর double inverted মধ্যে after giving opportunity of hearing to the applicants and other interested persons, comma, and passing a reasoned order in accordance with law, double inverted close, full stop. Next para. It is argued by the state that by such order dated June 16, 2014, comma, the tribunal reopened the entire issue and left it for the BL and LRO to independently come to its findings upon an adjudication on merits and in accordance with law, comma, by passing a reasoned order. Full stop. Next para. Subsequently, comma, the private respondents moved the tribunal again, time and again, upon which similar directions were passed. Full stop. However, comma, it is submitted that in all such directions, comma, the tribunal directed the BL and LRO to adjudicate the issue in accordance with law upon giving hearing to all persons interested, comma, thus keeping the adjudication and the issue open for being decided by the BL and LRO. Full stop. Lastly, comma, the BL and LRO, comma, by an order dated May 26, 2023, comma, pursuant to the direction of the tribunal, comma, adjudicated the issue by an elaborate and reasoned judgment, wherein it was held, comma, inter alia, comma, that the order of the SDL and LRO suffered from inherent lack of jurisdiction and as such is not enforceable. On such premise, the claim of the private respondents for mutation in their name was rejected. For sub next para, however, the private respondents thereafter moved the tribunal with an allegation of contempt. For sub next para, the matter was taken up by the tribunal at the first instance and disposed of by an order dated June 6,
Yes, June 6, my lord. June 6.
June 6, 2020, 2023, June 6, 2023, thank you. 2023, again directing the BL and LRO to take decide the matter in accordance with law. Full stop. Being aggrieved, the present private respondents challenged the same before division bench of this court, giving rise to WPLRT 104 of 2023, which was disposed of by a coordinate bench on October 3, 2023, which quoted the prayers made before the tribunal and came to the conclusion that the tribunal was vested with the jurisdiction to consider as to whether the order of the tribunal passed in OA 762 of 2014, dated June 16, 2014, was carried out or not. Full stop. In view of the tribunal having refused to look into such issues as per the division bench, the entire proceeding was remanded to the tribunal with a request to hear out and dispose of the same afresh, preferably within a period of 6 months from the date of communication of the order. Push up next para. Pursuant to the said direction, the first impugned order in the present writ petition was passed. Full stop. Next para. Learned senior government advocate contends that in view of the order of the SDLRO being a nullity, the BL and LRO complied fully with the order of the tribunal passed in OA 762 of 2014, which had provided the leeway to the BL and LRO to decide the matter in accordance with law upon giving hearing to all interested persons, and arrived at its conclusion that the SDLRO order was a nullity, and as such, the mutation sought by the applicants / private respondents cannot be granted. Thus, there was no contempt on the part of the concerned BL and LRO at all. That apart, it is argued by the state that the caustic remarks made by the tribunal in the first impugned order dated June 28, 2024 were unwarranted, since the BL and LRO had not flouted any order of the tribunal at all. Moreover, the direction passed by the tribunal in the first impugned order dated June 28, 2024 for the records of rights to be corrected in favor of the applicants / present private respondents was also dehors a law in view of the order of the SDLRO being a nullity in the first place. Next para. Learned senior counsel appearing for the private respondents vehemently opposes the prayer of the state. It is pointed out that there have already been 5 previous rounds of litigation and the private respondents have been compelled to run from pillar to post despite having a valid order by the SDLRO dated October 3, 2004, whereby it was categorically observed that the original intermediary Gopal Haith, who sold the property in favor of the predecessor interest of the petitioners, predecessor of the private respondents, was entitled to retain the subject property which was sold to the predecessor of the private respondents. Next para. it is contended that in the absence of any challenge to the said order, comma, the same has attained finality. For sub next para, that apart, comma, it is argued that the principles of issue estoppel and res judicata squarely apply inasmuch as the state, comma, before various forums, including the tribunal, comma, has taken a categorical stand by filing a compliance report that they have complied with the order of the tribunal dated June 16, 2014, passed in OS 762 of 2014. Full stop. Next para. It is further pointed out that the superior officer to the BL and LRO, that is the DL and LRO, comma, had written to the BL and LRO to initiate proceedings for cancellation of the patta, comma, also pursuant to the order of the SDLRO referred to above. Footstep, since such steps having been taken and the patta granted in favor of third parties having been cancelled, comma, the state cannot now resile from the rest of the order of the SDLRO and submit that the same is a nullity. Full thus, comma, it is argued that the BL and LRO acted without jurisdiction in flouting the order of the SDLRO, comma, thereby rightly incurring INCURRING the wrath WRATH of the tribunal in contempt. Full stop. Next para. Upon careful consideration of the contentions of the parties, comma, we find that the order of the SDLRO dated October 3, 2004, passed in miscellaneous case number 10 of 2004, was never challenged by the state. Full stop. As such, comma, under normal circumstances, comma, the said order would have attained finality. Full stop. However, comma, before coming to such conclusion finally, comma, we are to consider the argument of the state as to whether the said order is was a nullity, comma, being without inherent jurisdiction and as such can be ignored in law. Full stop. Next para. It is not in dispute that the tribunal by one of its orders in the previous rounds of litigation had granted liberty to the private respondents to refer the matter under section 57 capital B of the 1953 Act. Full stop. Next para. Such reference was, comma, thus, comma, duly made to the SDLRO under the said provision. Full stop. Next para. Subsection 2 within bracket small b of section 57 capital B provides that no civil court shall entertain any suit or application concerning any land or estate or any right in such estate if it relates to a dispute involving determination of the question, comma, either expressly or by implication, comma, whether a riot or an intermediary is or is not entitled to retain under the provisions of the said act such land or estate or right in such estate, comma, as the case may be. Full stop. Para. Subsection 3 of section 57 capital B provides that any dispute referred to in clause small b within bracket of subsection 2 within bracket may be decided by a revenue officer not below the rank of an assistant settlement officer, comma, specially empowered by the state government in this behalf, comma, who shall dispose of the same in such manner as may be prescribed. Full stop. Next para. Thus, comma, the SDLRO, comma, being a revenue officer as described in subsection 3 of section 57 capital B, comma, was empowered to decide the issue involving determination of the question regarding the entitlement of an intermediary to retain the land. Which of next para. The proviso to subsection 3 of section 57 capital B says that in deciding a dispute under the said subsection, comma, the revenue officer shall not reopen any matter which has already been inquired into, comma, investigated, comma, determined or decided by the state government or any authority under the provisions of the 1953 Act. Full stop. Next para. Thus, comma, the proviso introduces a legal fetter to a matter which has already been finally and conclusively determined, comma, to be reopened under the jurisdiction conferred on the revenue officer by subsection 3 of section 57 capital B. Full stop. Next para. Hence, comma, the nullity argument of the state cannot be accepted, comma, since at best, comma, the state could argue that a legal error was committed by the SDLRO by reopening an issue finally determined. Full stop. Inherent lack of jurisdiction sorry, this is not a case where the SDLRO did not have inherent jurisdiction, comma, since by dint of subsection 3 of section 57 capital B, comma, jurisdiction is conferred on such officer to decide questions relating to retention of an intermediary. Full stop. Moreover, comma, it is a mixed question of fact and law as to whether an issue has already been determined or not. And as such, comma, the proviso to subsection 3 does not comprise of an absolute bar to the determination by the SDLRO, comma, which would hit at the roots of the inherent jurisdiction of the SDLRO. Full stop. Next para. As such, comma, the order of the SDLRO was at worst, comma, illegal or erroneous in law and not a nullity. Full stop. Thus, comma, without any challenge having been preferred against the same under the provision of subsection 4 of section 57 capital B, comma, the said order has attained finality. Full stop. Next para. Looking from another perspective as well, comma, the vesting and retention of the lands of an intermediary happen under section 6 of the 1953 Act. Full stop. Under subsection 5 of section 6, comma, an intermediary shall exercise his choice for retention of land under subsection 1 within such time and in such manner as may be prescribed. Full stop. Crucially, comma, if no choice is exercised by him during the said period, comma, the revenue officer shall, after giving him an opportunity of being heard, comma, allow him to retain so much of the lands as do not exceed the limits specified in clauses small c within bracket, comma, small d within bracket, and small j of that subsection. Full stop. Next para. Thus, comma, the question as to whether there was a final determination as contemplated in the proviso to subsection 3 of section 57 capital B is dependent in the present case on whether an opportunity of being heard was given to the intermediary Gopal Haith even upon the said Gopal Haith having not filed form B for retention of land. Full stop. In any event, comma, the statute does not empower the state to vest more than the ceiling limit without have vest to state to complete a vesting process without completion of the exercise under subsection 5 of section 6, even if no form B was filed by the intermediary. Full stop. Next para. The plinth of the state apostrophe case is that no form B was filed at any point of time by the intermediary and the form filed by his heirs was unsigned. Full stop. Next para. However, comma, it is not the specific case of the state as reflected from its pleadings before the fora below, comma, that despite such form having not been filed for retention, comma, the exercise as mandated under subsection 5 of section 6, that is giving an opportunity of hearing to the said intermediary and allowing him to retain so much of the lands as not to exceed the ceiling limits, was complied with. Full stop. Hence, comma, it cannot be said as an absolute proposition that the SDLRO did not have power under section 57 capital B within bracket 3 to decide the issue, comma, since it is questionable as to whether the proviso thereto is attracted at all in the present case. Full stop. Next para. We further find that the argument of the state relating to the order of the tribunal dated June 16, 2014, passed in OS 762 of 2014, being merely a reopening of the entire exercise by the BL and LRO, to be unacceptable. Full stop. Next para. It is to be noted that by the said order, the tribunal categorically directed the BL and LRO concerned to take appropriate action for correction of LR record of rights in favor of the applicants on the basis of Annexure C to the application, within bracket, Annexure C being the order of the SDLRO, bracket closed. Full stop. Thus, the very basis of the direction was to correct the records of rights outright on the basis of the order of the SDLRO. Full stop. Thus, no leeway can be read into such exercise by the BLRRO merely by dint of the suffix SUFFIX thereto, to the extent that opportunity of hearing was to be given to the applicants and other interested persons, and a reasoned order was to be passed. Full stop. In any event, as rightly argued on behalf of the private respondents, even for the correction of records of rights as per direction of the tribunal, the formalities of law in giving a hearing to interested persons has to be given. Full stop. Next para. However, the BL and LRO went against the grain of the said direction, which mandated the BL and LRO to correct the records of rights in terms of Annexure C to the original application, that is the order of the SDLRO, by reopening the issue, including the order of the SDLRO itself, and coming to the conclusion that the SDLRO order itself was a nullity. Full stop. Thus, the BLLNRO went patently contrary to the specific direction of the order of the tribunal dated June 16, 2014. Full stop. Next para. The ambit of remand by the division bench on the last occasion was to consider the original application of the private respondents afresh, which included prayers for a direction on the BLLRO to dispose of the mutation applications, as well as to implement the order passed in OA number 762 of 2014. Full stop. Next para. Thus, the tribunal, by the first impugned order, was well within its jurisdiction to direct the BL and LRO to outright correct the records of rights in terms of the order of the SDLRO dated October 3, 2004. Full stop. Next para. Insofar as the second impugned order is concerned, we are of the considered opinion that there might have been a bona fide doubt in the mind of the BL and LRO, inasmuch as the orders of the tribunals directed opportunity of hearing to be given to interested persons, and for the BL and LRO to pass a reasoned order in accordance with law. Full stop. Next para. Thus, we cannot say beyond reasonable doubt, which is the parameter of ascertaining whether there has been a contempt of court, that the BL and LRO deliberately flouted the orders of the tribunal. Full stop. In fact, the order passed by the BL and LRO, for which the BL LRO is being hauled up, was a well-reasoned order, complying to such extent to the direction of the tribunal. Full stop. Thus, we cannot say that the BLLRO was guilty of contempt. Full stop. Hence, WPLRT 195 of 2025 is disposed of by affirming the first impugned order dated September 15, 2025, passed by the second bench West Bengal Land Reforms and Tenancy Tribunal in MA 1682/2024, MA 311/2025, within bracket OA 1319/2022, bracket closed, our bracket LRTT
No, no.
And
Now, first order is 28 June. my lord. Your
28
lordship
June? Achha, sorry.
Lordship is affirming 28 June. And MA is
Yes, you are
review
right.
and
You are right. Order date হবে 20 June 28 না disposition ঠিক আছে হ্যাঁ dated June 28 2024 passed in শুধু ওয়ে 1319/2022 ব্র্যাকেটে LRTT এইটুকুন so next para হ্যাঁ and expunging the remarks in the subsequent impugned order dated September 15 2025 passed in MA 1682/2024 comma and MA 311/2025 passed in connection with the said OA comma to the extent that it was observed that the BL and LRO had deliberately flouted the orders of the tribunal on several occasions. Pushed up next para. However, comma, the portion of the said order dated September 15, 2025, whereby the BL and LRO was directed to correct the records of rights in favor of the present private respondents is retained. Full stop. The DL and LRO, comma, South 24 Parganas, comma, in terms of the order dated September 15, 2025, shall ensure that the order is duly complied with by the BL and LRO. Full stop next para. In view of the pendency of the present writ petition for so long before this court, comma, we extend the time for compliance of the said direction by the BL and LRO Namkhana till December 15, 2020, December 12, 2025, December 10, 2025. Full stop. Next para, no arrest cause urgent certificate. Yes.
And proceedings before the LRTT?
Way has been disposed of, not disposed of by the previous order?
Way has been disposed of. They filed the review challenging that Way's order.
No, rest of the order we have affirmed. We have not. We have only expunged that caustic remarks against him regarding the content.
So, okay. We will go back to the LRTT then.
Why?
Because the LRTT has fixed the matter for compliance of the BLLR.
That remains.
Yeah, that
whatever
remains.
else remains.
Yes.
Only those remarks have been expunged.
Yes, yes.
Grateful to
I'm deeply obliged.
একটা line মেঘনা that করে দিন তো it is made clear that the rest of the order dated September 15, 2025, comma, apart from those which have been expunged above, comma, are hereby affirmed.
Lordship, may the Milord contemner get a chance to show cause rule as to why? Show cause. The insubordination Lordship is getting deleted. He has not been given the rule issue.
We have expunged those remarks.
Show cause chance was not given.
Expunge করে দিয়েছে
Lordship. Milord, Lordship has used that wrong date, that is, the SDLR order is not 3rd October, it is 18th October.
18th October.
57
That appears as
57B3 order is 18th October.
আচ্ছা মেঘনা একটু কন্ট্রোল ফাইন্ড করে না অক্টোবর 3 যেখানে যেখানে বলেছি সেখানে অক্টোবর 18 দ্যাট ইজ অক্টোবর 18
18th October 2024
অক্টোবর
2004
অক্টোবর 3 যেখানে যেখানে বলেছি অক্টোবর 3 টা কন্ট্রোল ফাইন্ড করে অক্টোবর 18 হয়ে যাবে
Grateful to
হ্যাঁ আপলোডটা ভুল করে করেন